Thank you, Melissa. Okay, good morning. We are on the record in Utah Utility Facility Review Board, docket 20-3503, Rocky Mountain Power Petitioner versus Midway City Respondent. We've confirmed before the hearing started that all 5 board members are on the line. So at this point, I'll just make a few reminders. Since this is a telephonic hearing, there are a few things we need to just be aware of. Please be cautious of talking over each other. Please identify yourself when speaking, and I can't remember if I did that once we went on the record. This is Thad LeVar. But if you need to interrupt or if you need to make an objection, please identify yourself, or anytime you're going to speak, indicate who you are. Please put your phone on mute when you're not speaking, and then just try to remember to unmute it when you need to speak. And with that, I think we'll go ahead to appearances and then deal with some preliminary matters and some of these filings we received late last week. So do we have anyone on the line for Rocky Mountain Power?
Yes, this is Brett Reich with Rocky Mountain Power.
Heidi Gordon with Fabian Van Cott for Rocky Mountain Power.
Thank you. For Midway City?
Corbin Gordon and Joshua Jukes for Midway City.
Thank you. And for Valley-wide opposition to large transmission lines?
Good morning. Mark Morris and Liz Brereton of Snow and Wilmer for Volt.
Okay, thank you. And Ms. Berry, who's the court reporter, I'll just let you know if you need to interrupt us or ask anyone to repeat anything. I know this is an unusual circumstance to be doing this all telephonically, so please feel free if you're having trouble to let us know if we need to do anything differently. Thank you.
Thank you.
So why don't we jump ahead into some preliminary matters? As I've reviewed some of the filings that came in late last week, I'll just kind of walk through it and make sure that no one sees anything differently than I do. So we received a hearing brief from Rocky Mountain Power that also has a request for summary disposition. And so that request seems to be a matter that we should at least discuss before we start taking witnesses. We have received from Midway City objections to various witnesses' written testimony, and it seems to me that we should address each of those as we move forward with each witness. If anyone objects to moving forward that way, any board member or party objects, please let me know, but it seems like we should deal with those one witness at a time. We've received Midway City's trial memorandum, and as I read that, it looks like kind of a summary of arguments, but I don't read a motion or a preliminary request into that. If I'm reading that incorrectly, please let me know. And then we have Midway City's due process objections that includes a request that the board take all available measures to protect Midway City's due process. So I read that as somewhat of a preliminary motion. So it seems to me we have a request for summary disposition and a due process request from Midway City that we probably should address, at least discuss preliminarily, and then some objections to several of Rocky Mountain Power's witnesses that we can address as those witnesses are called. Does any party or board member have any concerns with moving forward in that manner? First, I'll ask any board member if any board member has any objection to moving forward that way, please let me know. Yeah, I'm not hearing any. Do any of the parties object to moving forward that way?
Your Honor, this is Mark Morris for Volt. We have no objection to moving forward that way. I just wanted to note that we filed objections to the testimony of Mr. Lefebvre and Mr. Myers. We filed that about 10 days ago, I think. And so I just want to make sure the court had those in mind when those witnesses are called. But we're happy to raise those objections as we go. Also, we plan on filing a trial memorandum today. I inquired of the other parties if they had any objection to our doing that today. They did not. And there is no motion in there. It is merely a memorandum of law to assist the board.
Okay, thank you. Just for clarification, I received that was filed late Friday, Volt's joinder into Midway City's objections to the witnesses. I am not seeing in the docket a separate objection to witnesses that was filed by Volt. You say approximately 10 days ago. I'm not seeing that document in our docket.
I will look into that, Your Honor, and try and get back to you.
This is Brett
Okay.
Reich with Rocky Mountain Power. We have not received those objections either.
Have you received the joinder to Midway City's objections? That wasn't distributed by the PSC staff until this morning.
Yeah, this is Brett Reich. We have received the joinder.
Okay. Well, I'm not seeing the other objection that you've referenced, Mr. Morris, online, but perhaps we can, if that can be identified as we move forward today, we can do so. Why don't we move next to Midway City's due process objections? And let me just ask Mr. Corbin, if you want to clarify if you're making any preliminary request of the board. These issues, I think, were also generally raised at the scheduling conference, and we understand your interest in maintaining those objections. Are you asking the board to take any action with respect to those issues at this point of the proceeding?
This is Mr. Jukes, Chairman LeVar. Let me just respond briefly. Primarily, no, this is primarily lodged to preserve our objections in the event of an appeal and before this board. However, we do think that some of the due process arguments are intertwined with the merits of our arguments and the evidence that will be presented, and we ask simply that the board take that into consideration when evaluating the merits of our arguments. So, for example, there are some concerns about our ability to respond to the substance of these bids that were prepared, and we ask that the board do what it can to perhaps draw reasonable inferences or protect our due process rights in any way that it can find that is reasonable.
Thank you for that clarification, Mr. Jukes. That is helpful. Does any other party want to comment further on this particular document that was filed with the board, the due process objections from Midway City? I'm not hearing any. Do any board members have any questions for Midway City about this filing? Hey, I'm not hearing any there either. So let's move then to Rocky Mountain Power's request for, let me just make sure I'm saying it right. Request for summary disposition. Mr. Reich or Ms. Gordon, would you like to briefly discuss that request?
Sure, thank you. This is Mr. Reich with Rocky Mountain Power. That request is based on the conditional use permit issued by Midway City. Our position on that is that Midway City had some express conditions in the conditional use permit. Those express conditions included obtaining 3 bids from Rocky Mountain Power. As stated in our request, we submitted those bids to Midway City on March 26th of 2020. Midway City then had, under the conditional use permit, 15 days after the 3 bids were provided to select which construction option would meet its needs in terms of costs and functions according to the conditional use permit. That date was on April 10th of 2020. We reached out to Midway City after the deadline and asked for them to select an option. They did not. In addition to selecting an option after 15 days after receiving the bids, Midway City also, pursuant to their own conditional use permit, were required to raise the funds sufficient to pay for the project for the undergrounding of the line. They also were required, as stated in the conditional use permit, to obtain a vote by the Wasatch County Council to approve a location for the dip poles that would otherwise be alongside Highway 113 that's acceptable to Midway City. Because Rocky Mountain Power had previously obtained a conditional use permit from Wasatch County that did not include those dip poles or undergrounding of the line in Wasatch County. Midway City failed to meet the conditions required in the conditional use permit. And as stated in the conditional use permit, if they fail to meet those deadlines, then the conditional use permit states that the applicant may proceed with overhead construction with the following conditions. And then it identifies several conditions that must be met to move forward with the project with the overhead route. Since Midway City never chose a construction option, they never responded to our request to select an option and failed to meet the funding conditions that they imposed. It's our position that the conditional use permit, as stated, the express conditions contained therein, they failed to meet those, and therefore, under the conditional use permit, it's Rocky Mountain Power's position that they have the right now to proceed with the overhead project, subject to the conditions outlined in the conditional use permit.
Okay, thank you, Mr. Wright. In a moment, I'll give Midway City an opportunity to respond and also indicate the extent to which they agree or disagree with the factual issues that Rocky Mountain Power has proffered in connection with this. But before I do that, let me see if any board member has any questions for Mr. Wright before we do that. If any board member wants to ask questions right now, please jump in and let me know. Okay, I'm not hearing any. Ms. Berry, I hope I'm identifying myself frequently enough for your purposes. I'll try to keep doing that as we go along. Again, this is Thad LeVar. Why don't we go to
Yes,
Midway City?
I'm getting you. You're good.
Okay. Thank you. I'll move to Midway City and again, ask if you have any response to this and also specifically ask if you have a position on the factual issues that have been proffered by Rocky Mountain Power in connection with this request for summary disposition.
We do. This is Corbin Gordon on behalf of Midway City. So in order to get a directed verdict, there would have to be no dispute of any fact before this board, and there are significant disputes of fact. Under the conditional use permit, Rocky Mountain Power required to provide us with 3 qualified bids. And we have been working, as you saw in our trial memorandum, there are very distinct arguments that those bids are not qualified, that the specs included in the bids are not correct, and that several of the things that Rocky Mountain Power has put in the bid are not required nor necessary under the standards, the safety standards that are applicable to the industry. So our position is we do not have any obligation to proceed forward to do any of the additional requirements until we actually get qualified bids from Rocky Mountain Power. And the core of what you will hear today is much cross-examination that will establish that the bids as presented are not reliable and that we have not received those, and as such, we can't proceed forward. I mean, we need to get bids that are reliable so that we actually know how much money we're supposed to get or we're supposed to raise. So there is a distinct dispute of fact, and that's, in my opinion, the core of what we're going to be arguing here over the next day or two, is establishing that those bids are not reliable.
Okay, thank you. This is Thad LeVar. Let me go next to any board member. If any board member has any questions for Mr. Gordon at this time, please indicate that you have a question.
Yes, this is board member Jordan White. Just one question along those same lines to Mr. Jukes. I guess I'm just kind of wondering what your thoughts are in terms of, in the context of the statute, when would Rocky Mountain Power have any kind of acceptance or recognition or even a dispute with respect to whether or not their bids are accepted or qualified? I guess why I'm asking that is because I looked at the motion paper and it looked like there was an email indicating their indication they provided qualified bids, but I see nothing in return, any disputes, any challenges whatsoever from any of the other parties with respect to those bids. Can you help me understand?
Certainly. I mean, we've been in, I mean, my thought on that was we all know that we're going to be in this hearing today, that we've already had a petition, and on our side, we're asking that you, as a board, determine what the actual excess costs are going to be, and we received those bids just a little less than 3 weeks ago. So in my mind, we had already lodged our objections, and everybody understood that we were going to be arguing about that in this hearing. So I did not think that we needed to raise objections. I thought we already had. And so that's my position on that, is that we've done all the work, and you can see in all the pleadings that it's very clear that we object to the form of these bids, but it did take us a little bit of time to work through with our experts to establish that, which once again comes back to due process. So my position on that, we've already lodged our objections. They're already standing before this board.
That's helpful. So just so I'm clear, it's your position that within the statute, the board is to actually give their approval or blessing or have you of whether bids are qualified under the statute. Is that, just so I'm clear on that? Is that?
Yes.
Okay. All right. Thank you.
Part of the responsibility to determine what the actual excess costs are, you need to establish what the actual costs to go underground are. And so that's going to be one of the primary things you're looking at over the next couple of days.
Thank you.
Thank you. This is Thad LeVar, and for purposes of the transcript, I'll just note, I think Mr. White addressed his question to Mr. Jukes, but it was answered by Mr. Gordon. Am I correct about that, just to make sure the transcript is accurate?
That is correct, yes. Mr. Gordon answered that.
Okay, thank you. Any other questions from board members for Midway City? Okay, I'm not hearing any. Why don't we go ahead and move to Volt if they have any comment on this preliminary request from Rocky Mountain Power. Sorry, not preliminary is the wrong word. This request for summary disposition from Rocky Mountain Power. Does Volt have anything they want to add to this?
Thank you, Your Honor. This is Mr. Morris. Very little. We join in Midway's points opposing the motion. The point of this entire proceeding is to determine whether and how much Midway is going to have to come up with in terms of actual, excess costs to implement a means of putting this line in other than what Rocky Mountain proposes. But to get to those excess costs, you need the board needs to understand what the real numbers are for going overhead and what the real numbers are for going underground. And we respectfully submit that neither of those two numbers have been adequately calculated or presented by Rocky Mountain at this point. And so it is a legal and factual impossibility for Midway to know what it is supposed to do in order to exercise an option to have this line go underground.
Okay, this is Thad LeVar. Thank you, Mr. Morris. Does any board member have any questions for Mr. Morris at this point? I'm not hearing any questions from board members, so why don't we go back to Rocky Mountain Power? This is your request for summary disposition, so why don't I give you a moment if you want to add anything final to your request before we discuss it as a board.
Sure, thank you. This is Mr. Reich. In the conditional use permit, the requirement calls for, it says we require the applicant to provide 3 actual competitive construction bids prepared by qualified, bonded, and insured third parties in accordance with standard city policy to establish the actual cost of this construction. And our position is that we have provided those bids. They meet those qualifications. They have to be competitive. We've testified to Darren Myers that we used our standard procurement and request for proposal process that Rocky Mountain Power uses. We secured those bids. We sent the RFP out to 18 different bidders, as Mr. Myers has stated in his opinion. In addition, with respect to what Mr. Morris said, the conditional use permit actually has a true-up provision on page 18 that says once construction is finished on the underground line, the actual cost will be trued up, and either the applicant shall refund the overpayment to the city or the city shall pay the difference to the applicant. So there is a true-up provision in the conditional use permit. So I'd certainly disagree that there is any requirement to obtain a definitive number on excess cost if there's a true-up provision in the conditional use permit. That could be trued up at the end of the project. So the only dispute or the only evidence that Midway City presented was not a bid. They did not go out and contain a construction bid. They contained an estimate. And as you know, an estimate is a lot different than a bid. It's not binding. It's a high-level estimate of what the project could cost. So there's no controverted evidence that shows that those three competitive bids are not exactly what they say they are. Of course, Midway City might disagree with the price and say that they're too high. That doesn't mean that they're not valid, that they weren't qualified and competitive as we followed our process. So we would dispute that there's any controverted evidence. There's no bid that was provided by either Midway City or Volt that contradicts the bid submitted by Rocky Mountain Power. Thank you.
This is Thad LeVar. Thank you, Mr. Reich. Do any board members have any questions for Mr. Reich at this point? I'm not hearing any questions from board members, so we'll move to board discussion of the request for summary disposition by Rocky Mountain Power. Does any board member want to begin that discussion?
Yeah, this is Jordan White. I guess I'll kick this off. I mean, I guess my initial concern is I'm not sure if I'm comfortable with the board getting into the business of questioning qualified bids. I don't read that in the statute. It seems that Rocky Mountain Power has followed the typical practices. The question of whether or not they're qualified to me seems to go beyond that typical term of art of qualifications. It's almost like we're asked to be looking towards with a jaundiced eye beyond. In other words, they've followed their practice. They've let it out to competitive bidding, the 18 possible prospects. They got back the bids. I'm just thinking out loud here, but that's my concern. Is I'm not sure where this goes ultimately. Is that when will we ever get to a point where we feel comfortable, or what is our position to actually vet what it means to be a qualified bid? I guess that's my initial concern. Is where does this go ultimately, both in this proceeding and beyond that? Where do we actually come? Is a utility or other entity supposed to come before the board when they're actually doing their RFP process so we can bless that? That's kind of my initial concern. I'll just leave it at that for now.
This is Thad LeVar. Thank you, Mr. White. Any other board comments or discussions or motions at this point?
This is Dave Clark, and I understand and appreciate Commissioner White's perspective. Mine's a little different. I think, at least in my mind, I entertain the possibility that the bids could be demonstrated to be flawed without the presentation by the opponent of a competing bid. And I know we have representations in the filed testimony about the bidding process, but I'm inclined to want to have that testimony vetted so that we can hear cross-examination of the testimony. I'd like to assure myself that indeed the process is what it's been represented to be in the pre-filed testimony, or whether or not there are any factual challenges to that can be sustained through either cross-examination or the affirmative testimony the witness for Midway City. So in my mind, although it might be a bit thin, I think there's a factual controversy for us here to examine.
This is Thad LeVar. Thank you, Mr. Clark. Any other comments or motions from board members? This is Thad again. I'll just give my thoughts at this point. To me, there's at least enough of a factual dispute here, and a relatively manageable amount of testimony that we have to go through, that I'm not comfortable at this point voting for summary disposition where it seems like we have enough facts in dispute that it makes sense to move through the witnesses and the testimony. That's where I am. I'm ready to make a motion unless any other board members want to discuss it further, or anyone else wants to make any motion for action on the request.
This is Dave Clark again. Just so that you don't have to do all the work, Chair LeVar, I'll move that the motion be denied for summary adjudication of the permit.
Does any board member want to second or discuss that motion from Mr. Clark?
This is Glenn Wright. I'll second the motion.
Any further discussion of the motion?
Yeah, this is just Jordan White. I intend to vote to deny the motion, but I just want to make it clear that, in the balance of, in the context of the due process motion, et cetera, I agree that we should continue this discussion to fully, explore some of these issues. But I do want to make it clear that I am, I guess I'm voicing a concern for future issues that I don't believe it's the position of the board or within the statute to actually, decide what that means to be a qualified bidder. Because if that were the case, it should have been done, I think, much earlier in the proceeding, or somehow more descriptive in the statute. With that being said, I would vote to deny it for the reasons expressed by, Chair LeVar and Member Clark.
This is Thad LeVar. Thank you, Mr. White. Any further? So we have a motion and a second. Any further discussion from board members on the motion before we vote? I'm not hearing any, so we'll go to voting on the motion. Mr. Clark?
I vote yes on the motion to deny summary disposition.
And Mr. Fitzgerald?
I vote in favor of denial.
Okay. This is Thad LeVar. I also vote in favor of denying the request for summary disposition. Mr. White?
I vote yes, or in favor of denying the motion.
Okay, thank you. Mr. Wright?
I vote to deny the motion.
Okay, thank you. So that motion passes by unanimous vote. We're denying the request for summary disposition. And I think we're ready to go ahead to moving forward with the testimony. Does any party have anything else that they feel needs to be dealt with preliminarily before we move to Rocky Mountain Power calling their first witness?
Your Honor, this is Mark Morris with Bolt. I have looked through our filings, and it appears that the objections that I drafted many days ago were not filed. And so I plan on doing that immediately. They're on my system, and I thought they were there. So these are objections to Messrs. Lefevre and Myers testifying, and as the board indicated, we can address the reasons for those objections at the time they're called. Thank you. And I regret the oversight. We have a lot of staff working from home, and it just slipped through the cracks.
This is Thad LeVar. Thank you for that clarification. These are definitely unique times, but there will be opportunity to address the substance of your objections as they call each witness. So thank you for that clarification. And in terms of schedule, let me just make it, before we move to witnesses, let me just make a comment on schedule. As we discussed in both of our previous hearings, some board members have other obligations going on. So today we have to conclude by 4 p.m. And if the hearing continues till Wednesday, we'll have to conclude by 4 p.m. on Wednesday also. Tuesday and Thursday look clear to go up until 5 p.m. if we need all of those days. But just so you know, today we will need to finish by 4 o'clock. And just to also let everyone know, we typically, well, at least with Public Service Commission proceedings, we typically take a hearing break about every hour and a half or so. If anyone has any reason why they need to request a short recess, other than that, including Ms. Berry, if you need to ask for recess any more frequently than that, please jump in and do that. But otherwise, I'll be watching the clock and trying to get us a short break every hour and a half or so, and then, of course, a lunch break midday. And so with that, I think we're ready to go to Mr. Reich or Ms. Gordon for Rocky Mountain Power's first witness.
Thank you. This is Brett Wright. The parties discussed the order of witnesses, and we had agreed that Midway City and Volt would proceed first with cross-examination. They had identified the following 6 witnesses. Since we've already filed direct testimony on these witnesses, they had identified Jason Norleen as going first, then Benjamin Clegg, Darren Myers, Jake Barker, then Benjamin Lefevre, and Craig Michaelis. So I think that Midway City and Volt actually are going to start with the cross-examinations.
So let me just clarify: Are you going to introduce their testimony first, or they're going to be cross-examined before their testimony is introduced? I'd like a little clarification on the process we're talking about.
Okay, yeah, sure. We can go ahead and proffer the direct testimony of our witnesses.
And then, of course, we have some objections to those proffers that we'll have to deal with one at a time, I think. So do you want to start with the first witness that you intend to proffer?
Sure, that would be Jake Barker.
Jake Barker first? Okay.
Sure.
Mr. Barker, are you on the line?
Yes, I'm on the line.
Okay, thank you. Your volume isn't great. If there's anything you can do to improve the volume quality, that would be good.
He's just going to get a little closer to the speaker. He wasn't near the speaker. We're trying to stay somewhat apart in the conference room here.
Oh, sure, thank you.
This is Jake Barker. Can you hear me better?
Yes, that's much better. Let me just start by swearing you in. Mr. Barker, do you swear to tell the truth?
Yes.
Okay, and I am not seeing an objection to Mr. Barker from Midway, and I from what you said, I don't think there's an objection from Volt to this witness. Am I incorrect on that? Is there, if there is any objection to this witness, please indicate at this point. Okay, I'm not hearing any, so Mr. Reich, you can go ahead with this witness.
Your Honor, this is Corbin Gordon from Midway. We would like to invoke the exclusionary rule.
You'd like all witnesses, are you asking for that with respect to all witnesses in this proceeding?
Yes.
Okay, does any board member have any question for Mr. Gordon with respect to this request?
Yes, this is Glenn Wright. I have no idea what that rule is.
Let me explain. I apologize. It's common when we are in trial to invoke the exclusionary rule, which requires that anyone who's going to testify be removed from the courtroom while others testify so that they're not influenced by the testimony that they hear. So we're just asking that anyone who intends on testifying be removed, and that the only person that be allowed on the record and in the room would be the person testifying.
Let me ask this question, Mr. Gordon. Just from a mechanic's point of view, this is a public meeting and it's being streamed, so anyone can listen to it. you know, in a courtroom, when I've been in courtrooms and the exclusionary rule is invoked, it's typically pretty simple to just exclude the witnesses from the room. But is your request to discontinue streaming the proceeding also? Because we stream as a courtesy. It's not a legal requirement that we stream because we keep a court reporter and a transcript. But are you asking that we turn off the stream?
No, I am not. Absolutely not. I'm just asking that the witnesses be removed from the room, and then, I mean, I think you could order them not to listen to the stream until they testify.
Any other board members have any questions for Mr. Gordon about this request?
This is Troy Fitzgerald. I don't have any objection or questions regarding the request. There's no way for us to verify that it's happening, so it just has to be on the basis of representation from the party.
Thank you, Mr. Fitzgerald. Any other board comments or questions for Mr. Gordon before we move to other parties?
No, this is Dave Clark. I don't have any questions. I'd like to hear what the other parties have to say about the request, though.
This is Board Member Jordan White. My question, I guess, is I don't know if I'm opposed. I just, I don't know if we've heard that before in at least commission proceedings. What is the reason for it or the rationale for that? Just that might help.
And would you like me to answer that, Chairman LeVar? This is Corbin again.
Yes, Mr. Gordon, if you'd respond to that question.
It just goes to the reliability of the testimony that you're going to receive. There will be different things that we will be asking, the same things in some instances that we will be asking different witnesses. And from a fairness standpoint, it's not fair that everyone sits and listens to everyone else's answer and then potentially tries to coordinate. So in trial, this is a very common thing where to protect the integrity of the process, we just bring in one at a time and they testify and then they leave and the next person comes in, and that way there's no possibility of having testimony altered due to what they've already heard.
Thank you.
This is Thad LeVar. Any other questions or comments from board members before we move to the Rocky Mountain Power?
This is Dave Clark. So I guess I'm just wondering about the consistency of this request with any requirements under the Open and Public Meetings Act and its applicability to our proceeding.
Mr. Gordon, do you have any response to that question?
Yeah, I mean, this is, so you sit in really a quasi-judicial scenario here, just like in a court. Courts are open to the public, but the judge does have the power to invoke this rule, which is common in trials, to exclude the witnesses. And once again, it's just simply for the reliability of the process. So it wouldn't be, in my opinion, any violation. You are sitting in a quasi-judicial role here. You're creating a record, and you certainly, as a board, have the power to say, yes, we're going to grant the exclusionary rule and take witnesses one at a time. That's a very common thing that judges do.
This is Thad LeVar. I have one follow-up question to Mr. Clark's question. You're not indicating that district courts in Utah are subject to the Open and Public Meetings Act. Is that correct?
No, I'm not. I don't think that's an interesting question, but they are open to the public unless closed by ruling of the court.
Okay, just maybe one or two more follow-ups to that then. Would you view this excluding some witnesses from listening to the proceeding as some form of closing the meeting under the Open and Public Meetings Act?
I don't think so. I mean, once again, your primary job as a board today is to make sure that this is a fair process, and I don't think it's violating anybody's rights as far as wanting to listen in if they're giving testimony and you're concerned that it's going to make the testimony that you hear unreliable. And so I think your primary purpose today is make sure that occurs. And I think these witnesses fully expect and understand that they're coming in to give testimony. We're not excluding any of the public who's interested, but as parties who are going to be giving you information, I think you have the right to protect the process and the way that that is presented so that you can rely on it.
This is Thad LeVar. Thank you, Mr. Gordon. Any other questions from board members?
Yeah, this is Jordan White. Here's my question. I'm wondering, and maybe this is, a precursor to the response from Rocky Mountain Power. I'm wondering if it might just be something they would be considered doing voluntarily. My concern is that under the Open Public Meetings Act, there's actual misdemeanor and potential criminal liability for board members for violating that act. And so I'm a little bit concerned that we're out on a ledge without much backing other than just representations about the Utah administrative law.
This is Thad LeVar. I don't know if that was a question or not. Mr. White, did you want Mr. Gordon to respond to that?
Well, I guess I'm asking that for Rocky Mountain Power. I know they're going to be responding to this in a second, but that maybe that's something that we might want to consider as a board, or if they may be willing to do. In other words, just because really we're relying on their good faith and their willingness to do that. I mean, whether we order it or they just voluntarily do that. Either way, I guess I'm trying to think of the most safe route. I'm not opposed to that request. I've never heard that before in one of at least a commission proceeding. I recognize that's a common practice and typical core practice. I guess I'm just trying to walk the line between our obligations under the Utah Open Public Meetings Act and the request for the due process underpinnings that the Midway City is getting at, I guess. So again, it's just maybe a potential discussion point for the board, and then maybe a request for Rocky Mountain Power to consider whether they would do that voluntarily or whether we need to order them.
Okay, thank you, Mr. White. Any other comments or questions from board members before we move to Rocky Mountain Power, and then of course we'll move to Volt next also, because my understanding is this request applies to the witnesses from all three parties. Any other questions or thoughts from board members before we move to the next party? Okay, Mr. Reich or Ms. Gordon, do you have any comments on this request from Midway City?
Yes, this is Mr. Reich, and we object to that request. We're not voluntarily going to agree to that for several reasons. The first reason being that the parties in this proceeding have already filed direct testimony and rebuttal testimony. That testimony is a matter of public record, unlike a court proceeding where there's live witnesses that offer their testimony live and not written testimony. So this is in many ways different than a courtroom proceeding. And in fact, under the Facility Review Board Act, under Section 54-14-104, under the Rules and Procedures, says that the board may, pursuant to Title 63G of the Utah Administrative Rulemaking Act, adapt rules governing proceedings under this chapter consistent with this chapter and Title 63G, Chapter 4. So if you look at Chapter 4 of the Administrative Procedures Act, there are procedures for formal adjudicate proceedings such as this one, a hearing. This is not a trial, it's a hearing. So under the provisions in Utah Code 63G4206-1A, says the presiding officer shall regulate the course of the hearing to obtain full disclosure of relevant facts and to afford all the parties reasonable opportunity to present their positions. So I think that this hearing is different in some ways than a courtroom proceeding. The rules of evidence are somewhat relaxed. In fact, in this rule that we're referring to, it says the presiding officer may not exclude evidence solely because it is hearsay. So that's another reason. There's really no basis for invoking the exclusion. The exclusion is actually found in the Utah Rules of Evidence, Rule 615, And that rule says that at a party's request, the court must order witnesses excluded so they cannot hear others' testimony. But this rule does not authorize excluding a person whose presence a party shows to be essential to presenting the party's claim or defense. So it's Rocky Mountain Power's position that even under the rule, it's not proper to be invoked, especially in this hearing that's difficult enough where we can't see the witnesses, where we can't, it's difficult. We would like our witnesses to be present to hear the proceeding, to make it comply with the APA, specifically obtaining full disclosure in front of this board. So we do object to it.
This is Thad LeVar. Thank you, Mr. Reich. Do any board members have any questions for him before we move to Volt? I'm not hearing any board members indicate they have questions for Rocky Mountain Power, so why don't we go to Mr. Morris or Ms. Brereton? Do you have any comments on this request from Midway City?
Thank you. This is Mark Morris for Volt. We join in Midway's motion to exclude. Responding most immediately to the points Mr. Reich made, it's true that there has been a lot of coordination among witnesses before now because they've had an opportunity to confer with counsel, and they've all submitted their own written direct testimony in coordination with counsel. And so that concern under the exclusionary rule has now been obviated. And so I would submit that whatever public policy or reasons under open meetings for not excluding witnesses is largely obviated. But I share Mr. Gordon's concern that if these witnesses are able to sit here and listen to questions that have not yet been presented to them in cross-examination, that there is a risk that testimony is going to change. A simple example is there might be 4 witnesses. If the first 3 testify that the light was red, and the 4th one was going to testify it was green, it puts a lot of pressure on the 4th witness not to change the testimony and say instead, well, I guess it was red instead of green. And so that's what we're trying to achieve here. I agree with Mr. Gordon that the board is going to get the cleanest and most reliable testimony by excluding witnesses. One way I've seen it done is simply to put all the witnesses under oath at the beginning if they're available, and then the board could order them not to listen and simply to wait their turn to be called. I don't think that excluding 5 or 6 or 7 from the world at large, from the public, being able to listen to these proceedings and observe them is going to be prejudiced by asking only 5 or 6 or 7 people to wait their turn. And for example, as soon as Mr. Barker's done, he's welcome, once he's off the stand, if you will, to participate and watch. And so the world of people not able to participate or not able to observe these proceedings is going to shrink as we go. But I do share the concern that testimony could be modified in light of the cross-examination of early witnesses. The later witnesses are going to have an opportunity perhaps to reconsider what they were otherwise going to testify to.
This is Thad LeVar. Thank you, Mr. Morris. Do any board members have questions for Mr. Morris at this point? I'm not hearing any questions. Why don't I circle back to Mr. Gordon for any final comments on your motion before we move into board discussion?
I just want to reiterate that my motion is based on fairness and reliability. I want this process to be as fair as possible. I don't think it's fair to allow Rocky Mountain Power's witnesses to sit and listen to one another and potentially coordinate. And so based on that, I just renew and more than happy to abide by whatever the board decides, but I do lodge that objection that I don't think that's fair if that's the way you want to proceed.
Let me ask you this question, Mr. Gordon. As I'm looking at our legal options and obviously not wanting to violate the Open and Public Meetings Act, what would be your response to a board action to request all witnesses not to listen to the hearing until they're testifying?
I'll take whatever I can get, Your Honor. And so if that's as far as you feel comfortable going, then we'll abide by that. And my hope would be that they would respect the board's guidance there.
Thank you, Mr. Gordon. Any other questions from board members for Mr. Gordon at this point? I'm not hearing any, so why don't we move to board discussion of the request by Midway City?
Chair LeVar, this is Jordan White speaking, board member. If we were to entertain this request, and I think I've got the right statute in front of us, but do you have an opinion in terms of whether we would need to close this? I guess that's the one I'm grappling at. Is if we, typically, like in a commission proceeding, if we, actually close a portion of the hearings, there's certain reasons, confidential matters, proprietary, et cetera. Is this something that we should discuss, whether we would be required to at least close it if we were to that, or I guess the other option is just to make a request?
Yeah, this is Thad LeVar. If you don't mind me commenting a little bit on your comment too. Just for clarification.
Yeah.
Sorry, were you not finished, Mr. White?
No, I just think it's actually a question. I want you to comment if you wouldn't mind.
Oh, sure. Just for everyone's benefit, there is a statute in Title 54 that the Public Service Commission frequently uses to close hearings outside of the Open and Public Meetings Act, but I don't see any basis for that statute in Title 54 applies to the Utility Facility Review Board. I don't have that statute that the Public Service Commission uses frequently, but I don't think there's any argument to be made that statute applies to this board. So short answer is, while the Public Service Commission has some additional flexibility, I don't see that this board does outside of the Open and Public Meetings Act, which is why I asked the question about making a request. I'm not sure there's any basis under the purposes for closing a meeting in the Open and Public Meetings Act to do this. I think asking some participants not to listen or prohibiting some participants from listening is at least some form of closing the hearing. On the other hand, I'll give my own view that I haven't heard anything in the responses from Rocky Mountain Power that gives me any indication that they would be prejudiced in any way by having their witnesses excluded. I don't see any potential for prejudice to any party from having their witnesses excluded. I'm just concerned about what we do and don't have legal authority to do. So that's where I'm sitting. As a matter of fairness, I don't think it hurts any party to have the witnesses excluded. Since they all have read each other's testimony, I don't see any prejudice from not being able to listen to each other's cross-examination before they're cross-examined. But I just have some concerns about our legal path to doing that. So those are my thoughts. Do any other board members have comments or deliberation or discussion of this question?
This is Dave Clark. I personally would want some authority for this board taking the action that we've been requested to take because of the routine practices of this board, and also even though it's met infrequently, and the applicability of the Open and Public Meetings Act and how it relates to our function. and my questions about it, without some firm authority for taking the action that we've been requested to take, I would not impose it. I think I don't have an objection to requesting that witnesses refrain from listening to the other testimony being offered by the witnesses who are aligned with them. But I wouldn't do any more than request that.
This is Thad LeVar. Thank you, Mr. Clark. Any other board discussion or board motions?
I guess this is one. I agree that I agree with the sentiment that exclusion the witnesses goes against the purposes of the Open Public Meetings Act, and I would not support that motion. I'm okay with the compromise of request.
Your name, sir?
That was Glenn Wright.
Thank you.
Okay, this is Thad LeVar. Thank you, Mr. Wright. And Mr. Fitzgerald, I think you were trying to make a comment also.
Thank you, Chair LeVar. Yes, this is Troy Fitzgerald. I guess just from the board's perspective, just so I can stay clear on this, what set of rules are we even following here?
If you're asking from thoughts from board members, this is Thad LeVar. I mean, I think my short answer to your question is the Administrative Procedures Act and the Open and Public Meetings Act are mandatory on this board. The way I view those two acts, the rules of civil procedure are persuasive to this board, but not mandatory. But the provisions of those two acts, as well as the Facility Review Board acts, are the basis for our procedures. That's my view of it, if you're asking board members for their view.
Yeah, this is Jordan. I think I would. Oh, sorry, you go ahead.
Yeah, this is Troy Fitzgerald. If that's the general consensus, that's helpful for me to know which rules to consider.
Yeah, this is Jordan White. I wanted to just add on to that I see that as, again, it's similar to every other hearing that the Open and Public Meetings Act applies to. For example, a city council meeting, a city planning commission meeting, a legislative session. It's similar to that. It's hard for me at times to not think through the lens of Title 54, but I recognize this is a separate board apart from that, and so I think that Chair LeVar is correct. Those are the governing statutes, and we can utilize the rules of evidence and civil procedure as guides, but we're not like a district court. We're more like a planning commission or city council or something of that sort.
This is Thad LeVar again. To your question, Mr. Fitzgerald, I'll add one more personal opinion in that in the years I've been working on administrative law, I think it's clear that the Open and Public Meetings Act was not written very well for adjudicative proceedings. It was written for legislative proceedings. And it's not a great fit for quasi-judicial proceedings. But having said that, we are where we are, and we have the law that we have in front of us. And so that's my personal view of it. This is Thad LeVar again. Any further board discussion or board action? I'm not hearing any, so I don't object to making a motion myself that we request the witnesses of all three parties to exclude themselves from listening to the hearing while other witnesses are testifying and being cross-examined. If there's any discussion to that motion or a second to that motion, we'll entertain that.
This is Brett Reich with Rocky Mountain Power. Can I just ask what the basis of that motion is made under, what rule?
I think, is that question directed to Mr. Gordon? Or
Yeah,
the directed?
or the board, yeah, either one.
So I would say that you were granted the power to make that motion under 63G 4208, which specifically talks about the procedures for formal adjudicated proceedings and the orders that you may issue. Under Section 4, it says that this section does not preclude the presiding officer from issuing orders, interim orders to, down in C, otherwise provide for the fair and efficient conduct of the adjudicated proceeding. And under that portion, you're making a ruling for the fairness of this process and issuing an order based on your concern about fairness.
And I'll just explain my motion a little bit. This is Thad LeVar again. It basically boils down to I have concerns about our legal authority to order exclusion. However, I have not heard anything that leads me to believe any party or any witness would be prejudiced by excluding themselves from listening to the other cross-examination. I don't see how that's going to harm in an unfair way any witness's participation in the hearing to not have heard the cross-examination of other parties. So I do think it's a reasonable request, but as we've discussed, I have concerns about the authority to order it rather than request it. So that's the motion that I've put in front of the board at this point. So any further discussion? Mr. Wright, were you? Oh, Mr. Fitzgerald, go ahead.
Yeah, I was simply going to second that motion and state I've got a lot of experience with the Open and Public Meetings Act, and I agree with you. I don't think that it's binding because it is open and public. People can listen, but it does go to a party's willingness to participate in the proceedings and do what they can to make it fair. And so again, I will second that motion.
Okay, thank you, Mr. Fitzgerald. Any further discussion to the motion by any board member? I'm not hearing any further comments, so why don't we move to voting? Mr. Clark.
I vote yes.
Hey, Mr. Fitzgerald.
I vote yes.
Thank you. And this is Thad LeVar. I vote yes. Mr. White?
Yes.
Mr. Wright?
Yeah, yes.
Okay, thank you. The motion passes. So this board has made the request of all three parties, Rocky Mountain Power, Midway City, and Volt, to exclude your witnesses from listening to the testimony of other witnesses as this proceeding moves forward. And with that, I think I'm just trying to decide whether to take a short break now. I think we'll move ahead with Mr. Barker's testimony at this point.
Commissioner LeVar, this is Corbin. Just one thing. For purposes of the record, Midway City will honor that request.
Thank you, Mr. Gordon. Mr. Wright, do you want to go ahead and move forward with Mr. Barker? He's been sworn in, and I think it's back to you now.
I'm sorry, Mr. Chairman. This is Mr. Morris. I too am going to send an email now to the Volt witnesses conveying the board's request and asking that they not listen in on the proceedings. And before we proceed, I would like to know if Rocky Mountain is going to comply with the request or not concerning its witnesses.
Okay, thank you, Mr. Morris. And I think you also just convinced me that it's probably a good time for a hearing break just to allow parties to communicate with their witnesses. So I think we'll take a short break. But before that, I will just go back to Rocky Mountain Power to see if Mr. Reich has any further comments he wants to make to the board at this point.
No, it'll be a great time for a break.
Okay, with that, I think we will reconvene in approximately 10 minutes. So we'll be in recess for 10 minutes. Thank you. LeVar, and I want to clarify one comment I made previously. As we were discussing this motion, I referred, let me wait, it looks like our streaming isn't quite back on yet, so I'll wait a moment until it's back on. Okay, this is Thad LeVar. We're back on the record in Utility Facility Review Board Hearing 2035-3. I want to clarify one comment I made as we were discussing the exclusionary request by Midway City. I referred to our streaming as a courtesy, and that is normally the case when we have an anchor location that is open to the public. But I realized during the break that since we do not have an anchor location, and we're operating an electronic meeting in accordance with Governor Herbert's executive order, that our streaming is not a courtesy. It is mandatory unless we wanted to have anyone from the public on the phone line. So I should not have referred to the online stream as a courtesy. It is mandatory since we do not have an anchor location that's open to the public right now. So with that clarification of my previous comment, I think we're ready to move to Rocky Mountain Power presenting the testimony of Mr. Barker. Mr. Barker has been sworn in, and are you on the line, Mr. Barker, still?
Yes, I am.
Commissioner LeVar, this is Mr. Gordon. Can I just address just a couple of housekeeping issues here as we proceed?
Go ahead.
One, it was our intent to offer an opening statement that would outline the reasons that we're cross-examining and just kind of give the board the aid of what it is that we're trying to do. We would like the opportunity to do that. I'm not sure if the other parties intended on that, but we would like that opportunity before cross-examine begins.
Okay, thank you, Mr. Gordon. I'll go next to Mr. Morris. Do you have any desire or thoughts on opening statements before we move into witnesses?
Not knowing what the board's preference was, I haven't prepared a lengthy opening. I do have some initial thoughts that I wouldn't mind sharing just as a preview to help the board understand perhaps later why some of the questions we're asking in cross are coming up. So I think it might be helpful.
Okay, thank you. Mr. Wright?
We have no objection to opening statements.
Would you want, since were the original applicant in this docket, Mr. Wright, would you want to go first on any brief opening statement?
Sure. So, and you have a certain, are you talking certain time limit, or how much time would you like me to take on this?
This is Thad LeVar. My hope is that we could move forward without having to establish time limits. You know, we're dealing with expert witnesses, but also some issues of fact. We've all received, and I think all board members have read the hearing briefs that have been submitted. So none of us are coming into this cold, but I hope that gives some guidance. If there's a need to establish specific time limits, we could entertain that, but hopefully we could just move forward without being that specific.
Okay, well, then I will not repeat our position that we outlined in our hearing brief, and just spend a brief minute on some of our responses to some of the things that were mentioned in the other briefs. And I will not go back and repeat what we've already discussed about the bids and why we think that we have complied with the conditional use permit of submitting the 3 qualified bids by bonded contractors. The one concern that Rocky Mountain Power has throughout this entire process is the delay that continues to be the theme advanced by Midway City. As we stated in our testimony and in our direct testimony by Benjamin Clegg, we met with the city on June 13th of 2017 to explain this project. That was several years ago. At that time, they did not have a city ordinance that required a conditional use permit for transmission projects. In about that time, we filed applications with Wasatch County on October 31st of 2017, and also with Heber City on November 2nd of 2017. On December 14th of 2017, Midway City's mayor-elect asked Wasatch County to delay its approval of the county's CUP until she could take office and assess Midway City's position. In early of 2018, Midway City discusses its desire to amend the city code to add an ordinance making transmission lines a conditional use, which they did then a year later in January of 2019, when Midway City passed a city ordinance requiring transmission lines must obtain approval and they passed a two-step process. So both the Midway City Planning Commission and the City Council. And the reason I'm going over these dates, it's important to set, I think, the stage for the process that Rocky Mountain Power has gone through to obtain this conditional use permit for Midway City. It's not something that we're trying just to ram through the process. We've been talking to them for several years. As I stated, we started in as early as 2017. So once the ordinance was passed, Rocky Mountain Power applied for a conditional use permit on April 2nd of 2019. That is over a year ago. So it's taken us a year to get to this point. On May 14th of 2019, the Midway City Planning Commission held a public hearing. They requested some information from Rocky Mountain Power, which was given to them in July of last year. On August 13th of 2019, the Planning Commission voted to recommend the project to the City Council. So once we made it through the first step, we then had to go through the Midway City Council meeting. Even though that was approved by the Planning Commission on August 13th, the Midway City Council didn't even hold a public hearing until October 15th, where they took public comment. This also goes to the, I think, due process arguments that have been raised by Midway City. On November 14th and 16th, Midway City held public open houses to allow its citizens to speak about the project. Then on November 19th, another public hearing where the City Council received public comment. And on December 3rd, another public hearing was held to discuss this project. So the conditional use permit was finally issued by Midway City on December 17th of 2019. They approved the project and issued the conditional use permit that's now at issue in this proceeding. And so you can see it's been an extremely long process. And I think the fact that we're here today shows that there's some question to the finality of the actual permit that they issued in December 17th. The real issue for Rocky Mountain Power is not whether it's overhead or underground. The real issue is which one is it, and that we need to start going down that road. I know Midway City's taken the position, well, why don't we just wait till November? We can hold a bond hearing, and then we'll let you know, and then you can magically start construction the following spring. As this board knows, we can't wait until November to acquire, because we still have to acquire right-of-way. We've got to order long lead materials. If they wait until November to make this decision, that process can't start until after the funding is approved and we have the go-ahead for Midway City. So it makes it very difficult for Rocky Mountain Power to even make the following summer if this project continues to be delayed by Midway City. Both Wasatch County and Heber City have issued conditional use permits. We have those permits in hand. It's just Midway City that has continued to delay, and then now they continue to ask for delays during this process. So since RMP and HLMP filed its joint CUP application on April 2nd, it took Midway City 259 days to issue the existing conditional use permit. And it's been 384 days till today's hearing. So, the concern that we have is that this process is broken, and the city has continued to ask for delays, and we have worked extensively with them and provided the information. So the testimony that we've provided shows that there are some issues that need to be addressed to make sure we have reliable, safe power to the residents and businesses in the Heber Valley area. I think their witness even admitted that. He stated in his testimony that this work should be completed as soon as practical. I think the other position that they've taken is, well, you've had this problem in the past, so you can continue to have it for another couple of years, which seems nonsensical. I mean, we need to get this issue addressed. We've been trying to do it for several years now. And so we would ask this board to take action to assist in either, if it's overhead, great. If it's underground, great. We just need to know the direction and the parameters. So that is our opening statement.
This is Thad LeVar. Thank you, Mr. Wright. Mr. Gordon or Mr. Jukes, do you want to go ahead with your opening statement?
Mr. Gordon will make the opening statement. Thank you. Members of the board, we appreciate your willingness to come and spend the days and hours needed to prepare for this. To begin, I just want to state that this transmission line proposal has been one of the most difficult issues that Midway City has ever faced. And so it's important. And as far as moving forward here, I want you to think for a few moments. Normally, we would be together in a hearing and you would be able to see the amount of people, and we would have had many here in this hearing, and you would be able to sense and feel how important this is to our community. To begin, I want you to just, I'm going to refer to Midway's exhibits 15, 16, and 17. Those are pictures of Midway. We bring those up solely to kind of bring into focus why it is that we're so concerned. Midway City was established back in 1891, and since its inception, it's been recognized as a dream location for thousands of people who live there or who one day hope to move there. In 2017, it was named the best small city in Utah by a KSL poll, beating out 64 other communities. This wasn't by accident. Midway City is nestled in the northwestern part of the Heber Valley. It is surrounded by majestic mountains and sits beneath the watchful eye of Timpanogos, which is one of the most beautiful scenic vistas in the entire world. It is surrounded by Wasatch Mountain State Park on the northwest and south. Deer Creek Reservoir sits directly south, and there are 3,500 acres of open farmland to the east in what we call the North Fields. It is not hyperbole to say it is one of the most unique and beautiful places in the world. It is a home to Swiss days, the ice castles, and the Homestead Crater. And last year, its citizens approved an open space bond that will preserve hundreds of acres of open space in the town. For a moment, I just want you to imagine that you own a home in Midway so that you can understand fully the impact this is going to have. You love your land and your neighborhood, and you feel it's a privilege to live in such a beautiful place. You recognize that your home is close to a 46 kV line, but have no concerns regarding the line because there is already a 138 kV line just a half mile away that is similar in size to the line in the front of your house. Now imagine how you feel when Heber Light and Power and Rocky Mountain Power puts in the first phase of the proposed transmission line along Highway 40, and you realize that because this is a joint project with a double circuit on the poles, the joint project increases the size of the infrastructure to proportions that more resemble the gates of Mordor than the peaceful and quiet Shire that you're used to. The poles are distinctly industrial, making the clash against the agrarian backdrop all the more distinct. So suddenly, instead of living in the shadow of the everlasting hills, pun intended, homeowners are being told that they are going to live in the shadow of the everlasting power poles that are up to 100 feet tall and 8 feet in diameter, and many of the largest poles will be placed directly in front of people's homes. As you can only imagine, the proposal has been controversial from the start, with many of Midway citizens feeling this is a life and death battle to preserve its community as a more rural and agrarian atmosphere. While I recognize most communities do not have the political willpower to even consider burying a transmission line, Midway City is not most communities. It has already paid to have a survey done to determine the citizens' willingness to pass a bond to bury the line, and the results came back with a 70% in favor. So now thinking of your home in Midway, if you owned one, imagine knowing that there was a very real possibility of passing a bond to bury the line, which would minimize the effect on the line on your home and your community for centuries, not just decades, but centuries to come. But being told without basis in fact that Rocky Mountain Power must have the line in no later than the end of 2020 or rolling blackouts could occur. Imagine knowing that these claims are either not true or greatly exaggerated, and how frustrated you would be knowing that with a little more time, the money could be obtained to bury the line. That gives you the perspective of a vast majority of the citizens of Midway City, many of whom are listening to this proceeding today and would be in attendance if not for the coronavirus. I invite you to periodically look at the pictures I've referred to as we proceed with this trial so that we do not lose perspective on why we are here. Now, moving forward, as I speak this morning, I'm going to ask you to write a few things down, only because I want you to hold me accountable as this trial proceeds. I'm going to tell you what Midway City intends on showing over the next several days and the conclusions that follow once the evidence I will outline is heard. As an overview, RMP and Heber Light and Power are proposing a double circuit 138 kV transmission line through Midway City. This means that there will be two separate lines, one for RMP and one for HLMP. The joint use of poles cannot be minimized because doubling the circuits has doubled the weight and stress on the poles, requiring them to be 40 to 50 feet higher and 2 to 4 feet thicker than the existing wooden poles, and will replace current corner structures with hulking metal poles some 100 feet tall and 8 feet in diameter. This line runs through a peaceful rural residential neighborhood under the shadows of Mount Timpanogos, and some of the massive corner structures will literally be in some of our residents' front yards. Once installed, this line will have a permanent negative impact on this neighborhood for decades, if not centuries. We understand that Rocky Mountain Power wants to run the lines overhead on the skyscraping poles. This is the cheapest and the easiest solution. Of course, none of Rocky Mountain Power's employees live in this neighborhood, and I don't believe that if any of them did, they would be fine with staring at a 100-foot transmission tower in their front yard. The citizens who are going to be impacted by these tower and power lines are very concerned, which is understandable. Midway City and its residents want to bury the line and are willing to pay to bury the line, but cannot get a straight answer regarding what the actual cost to bury will be. I will discuss with you the problems with the submitted bids here in a second. Until Midway gets a straight answer, it cannot raise the money needed to bury the line, which will likely be a general obligation bond. RMP insists that this line must be completed by the end of 2020 or the sky will fall. We will show that that's simply not true. No harm will come if the commencement date of the Midway City portion of this line is postponed for 4 or 5 months to give Midway the opportunity to bond. The board has two jobs today. Number one, to determine what the actual excess costs are of going underground, and number two, what the appropriate commencement date should be for Midway City's portion of the line. Regarding the actual excess costs, Midway will show that Rocky Mountain Power has failed to provide it with reliable information needed to determine those actual excess costs. And because of this, Midway City's obligation to pay for those costs as established in the conditional use permit have yet to be triggered. We will show the following through cross-examination. Due to serious mistakes in the specifications given to the 3 approved contractors who bid to bury the line, the bids have come in anywhere from $3 million to $5 million high. The bids are not accurate, are not reliable, and cannot be accepted by this board as reliable evidence needed to determine what the actual excess costs to bury the line are. For example, in addition to being extremely high, the bid amounts themselves vary from $12 million to $28 million for only 1 mile of work. Next, we'll show that RMP has included several items in their bids that have no justification from a safety nor reliability standpoint. First, Rocky Mountain Power put forth specifications that require dual trenches to bury the separate 138 kV line. There is no safety standard that requires dual trenches and no justifiable reason to have 2 trenches, especially where it doubles the cost that RMP wants Midway and its taxpayers to pay. Further, RMP specs require an extra conduit to be installed on each circuit. Midway does not disagree with the need for the empty conduit, but Rocky Mountain Power also included the spec that a dead line be pulled through the circuit that will just sit there and possibly never be used. There is nothing in any industry standard that requires this extra expense, yet it increases the cable cost by 1/3. The evidence will show that not only are the bids fatally defective due to mistakes, but Rocky Mountain Power is asking Midway City to install a Cadillac where a Honda would do the job. Midway City's expert, who has been doing this for 50 years, will testify that the cost of the line without mistakes would be $8.1 million. And if you take out the glamorous extras of dual trenches and extra conduit, the cost drops to just over $5 million. When we are done showing you this evidence, we will ask you to either adopt our experts' valuations of the underground costs or require Rocky Mountain Power to provide bids based on correct specifications and trimming the fat. Once the actual costs to bury are established, the next step in the analysis is to establish what the actual costs of the easements needed for the line are. There is no question that easements will be required to build the massive poles in Midway's residents' front yards. There's also little question that planting the poles and lines in front yards will negatively impact the value of the surrounding properties. But there is a dispute regarding what exactly it will cost to buy the easement and compensate landowners. Rocky Mountain Power has the burden to prove this, but has estimated all of it at a mere $20,000. The board will hear from two competing experts, one from Rocky Mountain Power and one from Midway, regarding the estimated value of the easements. I want to underline and highlight estimated because neither witness's testimony is going to be sufficient to meet the requirements of the statute. The statute requires this board to determine the actual costs of the easements. The only way to do that is to either have Rocky Mountain Power buy them from the landowners or condemn. Until one of those two actions happen, there is no way for this board to determine what the actual costs of those easements are, which means it cannot determine what the actual excess cost to bury will be. As part of its power to determine the appropriate commencement date on this line, we will ask this board to issue an order stating that commencement of the line cannot commence until the easements for the line have actually been obtained. There is nothing in the statute that suggests the actual costs of easements can be determined by estimate. Once they are obtained, the actual costs of the easements will be established and can be submitted to the board so the actual excess costs can be determined. This board has the power to request information that was supposed to be submitted by Rocky Mountain Power but was not, and also has the power to suspend the hearing until the information is provided. Once the missing information is provided to the board, it has 30 days to issue a decision. We will ask the board to exercise this power, requesting updated bids and the actual costs of easements before reconvening. Next, regarding the appropriate commencement date, Midway City will show that Rocky Mountain Power's insistence that the line must be finished by 2020 is contradicted by their own witnesses. Rocky Mountain Power claims that rolling blackouts will occur if the line isn't finished on the timeline they propose. We will show that Rocky Mountain Power's own studies establish there is no immediate risk to its customers if the line is delayed a few months to bond. The area is currently served by 3 different transmission lines, and Rocky Mountain Power's own experts will establish that the claimed threats of system failure, once analyzed, are so remote as to be non-factors. The evidence will show that neither Heber Light and Power nor Rocky Mountain system is currently exceeding acceptable loads, and that neither will do so through the end of 2022. Heber Light and Power system only gets in trouble if it loses all of its generation and its north line at the same time, the likelihood of which is minuscule. Rocky Mountain Power admits that if one of its transmission lines goes down, it could redirect power through the other lines to keep its system at acceptable voltages. So the risks Rocky Mountain Power is using to justify a commencement date for today is based on catastrophes that are so remote and would be so devastating that none of its systems would survive regardless of whether this line is finished or not. And finally, all of this is an academic exercise in the first place because Rocky Mountain Power has not obtained any of the needed easements to commence the line in any of the jurisdictions the line passes through. There are 7 miles of easements that need to be obtained, and the conditional use permits in Wasatch County, Heber, and Midway all prohibit Rocky Mountain Power from commencing construction until the easements are obtained. So the likelihood of this line even starting in 2020 is low, and being finished in 2020 is almost an impossibility. Add in the delays that have come from COVID-19, and we have a situation where we're really fighting over nothing. Midway wants time to pass a bond and should be allowed to do so. Rocky Mountain Power loses nothing by waiting for the bond. The evidence will show that the delay is justified and that the board should use its power to establish the appropriate commencement date for the Midway portion of the line to be in the spring of 2021. not only because the line will still be in construction at that time, but because there is no legitimate reason to justify foreclosing Midway City's chance to bury this line and to minimize its visual and health impacts. I appreciate that was a little long, but I wanted to make sure that you understood where we're coming from, and we will outline, that gives you an outline of what it is that we will be cross-examining the witnesses on to establish. I appreciate your attention.
Thad LeVar, thank you for your statement, Mr. Gordon. Mr. Morris or Ms. Brereton, do you have an opening statement for Volt?
We do. Thank you, Chairman LeVar. Again, this is Mark Morris. Ms. Brereton and I have the privilege of representing a group of landowners and have represented them for many months now, who from the beginning have had grave concerns about not just the aesthetic, but the impact on their lives living around and under these proposed transmission lines. To further explain, I mean, these people are citizens of Midway, and vicariously, I suppose, Mr. Gordon is very ably, representing their interests as citizens of Midway. But their concerns and their commitment to having this done in the right way are such that among themselves, they have already raised privately $600,000 to bury these lines. They have all collectively agreed that they will not charge any fees or costs for Rocky Mountain to go underground and obtain whatever easements may be necessary to go underground. On the other hand, they are committed to getting the value that Rocky Mountain Power will be taking away from their homes if these lines go overhead. As Mr. Gordon ably expressed, and Rocky Mountain must concede, Rocky Mountain does not have the easements and rights-of-way. And I think in Mr. Reich's opening statement, he conceded that they still have to go and get rights-of-way in order to build merely this approximate mile-long line through Midway. They have not done so, and the idea that they have budgeted $20,000 or $25,000 or $27,000 for all of the easement acquisition they anticipate here it's insupportable. And candidly, people scratch their head as to what the motivation here is to suggest that. The evidence that we're going to present will show this is not the first time that Rocky Mountain has woefully underestimated the amount of money it is going to have to spend in order to obtain not only right-of-way, not only physical land, but also pay severance damages to landowners whose properties lie along this proposed route. About 6 years ago, Rocky Mountain proposed to build a substantial line through Tooele County to service the data center operated out at Fort Williams. They proposed in that case that $70,000 was all that they would need to purchase what they needed to in order to run their towering lines through that land. Well, after the lawsuit and after a lot of proceedings, they ended up paying $2.5 million rather than $70,000. What we have heard heretofore from Rocky Mountain Power is, well, we'll true it up at the end. Well, we'll figure it out at the end. And, well, it's not up to us. It's up to a judge or a jury someday to decide what this is worth. Well, that's not good enough for these particular citizens who belong to Volt and who are living near Midway to, after the fact, try to get compensation and get into litigation with these people because the offers if you split that $27,000 among the landowners near this line, would never be acceptable or accepted. It is primarily Rocky Mountain's failure to properly account for the easements and rights-of-way and the severance damages that are coming from going overhead into its costs that we think is the primary failure, and in failing to get to Midway appropriate standard costs to build this line. Among the facts that are not disputed, I don't think, in this case, but that the board should nevertheless take into account, is that Rocky Mountain does not have any recorded easements. Heber Light and Power does have a line going through here, but our investigation, and we've seen nothing to the contrary, shows the board that any easements or rights Heber Light and Power has that it may intend to confer or have agreed to confer to Rocky Mountain Power here are prescriptive in nature, and that no landowner has voluntarily signed anything or recorded a document saying, I hereby give to Heber Light and Power X number of feet or an easement through my property. But because the lines have been there so long, prescriptive rights have arisen. But under Utah law, prescriptive easements are limited to their original uses, and you can't expand them. And having a single-lane road through a property does not give you a right to build an 8-lane highway. After the construction, Heber Light and Power will continue to own and operate facilities in these easements to provide service to Midway City and residents. But this double-circuit transmission line requires rights-of-way that I think Rocky Mountain concedes, and its appraiser concedes and wrongly assumed would be 55 to 60 feet in width along the route. Those easements do not currently exist. These citizens should not have to have this line go through, get built, and then look forward to months or years of litigation trying to get their money out. They've come forth voluntarily. They've dug into their own pockets to do this. They're going to be digging into their pockets as taxpayers of Midway for a bond. And they have voluntarily been willing to allow the line to go underground and waive any claims that they might have to the easements that would be necessary for the underground transmission. That collective will should dissuade the board from allowing Rocky Mountain to go through on the basis of the I searched for a word that isn't going to offend everyone, but it's just flimsy. The bids and the way they've gone about trying to grossly overestimate the amount of money it's going to cost to bury a line for a mile, $28 million. It boggles the mind that someone is seriously suggesting it's going to cost that much to go a mile underground, $28 million. The fact that they only got 3 bids out of 18 people they purport to send this out to suggests that and implies a necessity that the conditions and restrictions that Rocky Mountain put into this RFP made it so unattractive that only 3 people were willing to bid, and those 3 jacked up the price horribly. So for these reasons, we asked the board to, and I think at the hearing on our motion to intervene, we made clear that the relief we seek is the same relief that Midway is seeking. And we're grateful that the board has permitted Volt to intervene here, to have its concerns aired, and to have it be given an opportunity to cross-examine and present evidence that show this needs to be a thoughtful and careful and fair process, which under the rubric that Rocky Mountain is suggesting now, it would not be. We're grateful for your time and look forward to participating in these proceedings.
This is Thad LeVar. Thank you, Mr. Morris. And I think with that, we're ready to go to Rocky Mountain Power's first witness, who you've indicated is Mr. Jake Barker, who has already been placed under oath. And if he's on the line, Mr. Reich, you may go forward with presenting his testimony.
Thank you. Mr. Barker, have you had an opportunity to review the direct testimony that was prepared and submitted under your name?
Yes, I have.
And is it an accurate representation of your testimony in this proceeding?
Yes.
Do you have any updates or changes to make to that testimony?
No.
In preparing that testimony, I know there were some documents that you relied on and that have been produced in this proceeding. Let me refer you to a document that's entitled, been Bates numbered RMP 125. That document also has been identified as a confidential document. Can you explain what this document represents?
Yes, so we build in planning, we build a model of the transmission system so that we can run contingency analysis, not necessarily wanting to experience those contingencies and look at the metered values. So we build models to simulate those types of contingencies. And so this document goes over the worst case contingencies in the Heber Valley area transmission system and the results from that model and studies.
Okay, and so on this document, Bates numbered RMP 125, it refers to some different percentages and some adjustments and some other. Did you rely on this document to provide your direct testimony?
Yes, that's correct.
Okay. Did you help in the preparation of this document?
The senior transmission planner for the Park City area prepared this document. I reviewed it and approved it.
Okay. In your testimony, you refer to a standard of Rocky Mountain Power Planning Standards for transmission voltage require the voltage to remain above 90% of nominal voltage. Is that true?
Yes, during an outage.
Okay. And is that identified in this exhibit, RMP 125?
It's shown in red. Anything that goes below 90%, we showed in red. We didn't explicitly put the 0.9 on that document.
Okay. Let me turn then to another document that you have that has been produced in this proceeding, identified as RMP 128. Did you see that document?
Yes.
And what does this document represent?
This is a one-line diagram of the transmission system in the Heber Valley and Greater Park City area.
Okay. And then there's documents identified as RMP 129 through 135. Are those documents that you are familiar with?
Yes.
And what are these?
These are the loading values on transmission transformers in the area.
Okay. And were these produced in this proceeding?
Yes.
Okay.
They come from a database that we keep up to date, and the actual documents were exported from that database.
Okay. And then, look, if you're looking at RMP 136 through 138, what are those documents?
So these are also a one-line diagram. This is a graphical representation of the model that we, in planning, run to simulate the contingencies. And it shows the voltages and power flow megawatts on transmission lines in the area under different contingency analysis.
Okay. So did you rely on this information for your direct testimony?
Yes.
Then finally, on RMP 139, what does this document represent?
This is the outage history on the transmission lines in question over the last 5 years.
Okay. So we would then proffer Mr. Barker's testimony, his direct testimony, along with those exhibits that he identified and provided a foundation for.
Thank you. This is Thad LeVar. If any party objects to that proffer, please indicate your objection. I'm not hearing any objections, so the motion is granted. Thank you. You can go forward.
Okay, so would that mean that now Midway City can proceed with cross-examination, Your Honor?
Mr. Reich, do you have any other questions for Mr. Barker before we move to cross-examination?
I do not.
Okay, then yes. Why don't we go ahead to Midway City next for any questions for Mr. Barker?
Thank you. Good morning, Mr. Barker.
Good morning.
You are the Director of Transmission Planning and Power Quality for Rocky Mountain Power, correct?
That's correct.
And you are in charge of applying reliability standards to Rocky Mountain Power's system, correct?
That is not correct.
So you're not the one that oversees the reliability standards for Rocky Mountain Power?
No, I do not.
Okay.
That is a function of our main grid transmission planning department. I'm the director of what we call our sub-transmission department. We do support the main grid department in their reliability standards, but I am not over the submittal or study of those standards.
So I just want to make sure that I'm who I'm talking to here. In your testimony, you indicated I am responsible for ensuring that Rocky Mountain customers receive safe, reliable, and efficient energy. I do this by applying reliability standards to Rocky Mountain Power's transmission system and planning for necessary upgrades to the system to provide additional capacity and improve electric service reliability to meet power requirements. So the core of my question comes from that. Is that not accurate information in your testimony?
That is accurate. As I stated, we do support our main grid department in their reliability assessments, and so part of our purview is to follow those standards. Your question was, am I in charge of those standards? And I am not in charge of those standards.
Okay, well, actually my question was, are you in charge of applying those standards? And so is that part of your job, is making sure that the Rocky Mountain Power system applies the appropriate reliability standards?
Yes, that is part of our position, yeah.
Okay, very good. Were you involved in creating the specifications given to the parties who bid to bury the underground portion of the line?
No.
Who was?
That's a question for the other witnesses.
Well, if you know it, you need to answer my question. Who did it?
I do not know who in particular was in charge of putting those standards together.
Okay. Did you review them before they went out?
No, I did not.
So your testimony today is that you really couldn't testify that those specifications are applying the appropriate reliability standards needed for Rocky Mountain Power system, correct?
Can you ask that question again? That wasn't clear.
Sure. I'm asking you, if you didn't review those, the specifications on the bids before they went out, then you couldn't testify today whether they appropriately apply the reliability standards, that the reliability standards for Rocky Mountain Power System, correct?
I don't believe that's the specifications are construction standards. In planning, my concern is that a 138 kV connection is made between Jordanelle and Midway substations. As long as that standard is met, then I don't need to review construction standards.
But once again, I go back to, you didn't review the specifications, correct?
Correct.
And so you don't know whether they meet the appropriate standards or not, correct?
I know that the connection between Jordanelle and Midway will be made.
Did you review the specifications in the bid? Just answer my question. Did you review the specifications in the bid?
I did not review the specifications in the bid.
So you cannot testify as to what those specifications contain, correct?
Objection, you've asked and answered. He's answered this several times. You're badgering him.
No, well, he hasn't answered it yet. He keeps trying to explain around it. I just need a simple yes, no answer to, he never looked at the specifications.
And he's given you that answer 5 times. He did not look at the specifications.
He never said that on the record. So if that's your testimony, did you?
This is Thad LeVar. I'm going to jump in, and I'm going to grant the objection on asked and answered. I think we do have that answer. And typically with expert witnesses, I'm not inclined to limit them to yes or no answers if the expert is inclined to give further explanation.
That's fine. I just didn't feel like he answered the question, but I accept your ruling and we'll move forward. Mr. Barker, many of the questions that I have for you, I expected to be about the specifications because I believe you were presented as the person that kind of oversees these things. I'm going to ask these questions, but I'm not sure that you're going to be able to answer them. The specifications require dual trenches for the buried line, correct?
As I understand it, yes.
Okay. But there is nothing in safety or reliability standards in your industry that require dual trenches, correct?
This is not applicable. The second trench is for Heber Light and Power's line. That line is not applicable to the reliability standards.
Let me ask you a simple question. Is there anything in safety or reliability standards that says you cannot have 2 lines in the same trench?
Not that I'm aware of, no.
Very good. So the desire to have dual trenches is not based on safety standards or reliability standards, correct?
I can't address the safety standards because there are 2 different entities operating those 2 lines, and they would be in not just the trench, but also in the same vaults. And so there are some safety concerns that I wouldn't be able to address. That question's better for another expert.
Who else would I ask on that?
From the reliability standards standpoint, there isn't a reason. But from a reliability standpoint, there is adequate reason, in my view.
Okay, so on the safety issue, then you're saying you can't testify to that. There would be another witness that could. Who would I ask that question to?
Ben Clegg or Darren Myers, who are more familiar with the specifications that were provided.
Perfect. Thank you. Okay. In the specifications, there's also the requirement to not only provide an empty conduit for each circuit, but to have a dead line pulled through that circuit, correct?
Let me file an objection here. I'm not sure I understand this whole line of questioning. Mr. Mr. Barker his direct testimony has to do with the purpose and need for this project. It's not construction specifications. He has no responsibility for constructing the project. His testimony, your line of questioning is outside the scope of his testimony, which is about the purpose and need of the project.
Well, this is Thad LeVar. I'll jump in just to confirm that was Mr. Reich who made the objection, correct?
Correct. Sorry, I did not identify.
Sure. And so, Mr. Gordon, can you identify where in the direct testimony this issue is raised?
Yes, they presented him as the person who is the transmission planning and power quality director for Rocky Mountain Power. He's the guy, right? And they put him forward saying that he oversees the system needs and the reliability of this system. And so I have every right to question him and assumed he would be the only one that would have the capacity to testify as to the reliability questions regarding dual trenches and the reliability questions regarding pulling a dead line that won't be used in the specifications. If he's not the one, then I don't know who else is. And so maybe I misunderstood, but what they've set him forward as is the director of the transmission planning and power quality. He is completely the person that we should be asking these questions to.
Mr. Reich, do you want to give any final comments on your objection?
Sure. Under the purpose of testimony, it says the purpose of my testimony is to discuss the purpose and need for this project. Then Mr. Barker outlined the reasons why this project needs to be put into service. His title is Director of Transmission Planning. It doesn't have anything to do with construction specifications. So I don't think there's anything in his title or in the purpose of the testimony that implies he's the guy to talk about construction specifications. We've identified the project manager, Mr. Myers, who was responsible for the request for proposal for the bid specifications. We provided his testimony. To say Mr. Barker is the only one that can testify about that is absurd. So Mr. Barker is here to testify about the need for this project based on his direct testimony that we provided.
In response to that, let me actually read his testimony into the record so we all get this straight. As the Director of Transmission Planning and Power Quality, I am responsible for ensuring that Rocky Mountain customers receive safe, reliable, and efficient energy. I do this by applying reliability standards to Rocky Mountain Power's transmission system and planning for necessary upgrades to the system to provide additional capacity and improve electric service reliability to meet power requirements. So am I being told that I can't ask him about questions regarding the safety, the reliability, or the efficiency of the specs that were put out for bid?
Okay, thank you. I think I understand the objection and the responses to them. This is Thad LeVar. I'm going to speak to the other board members for just a moment, since this board doesn't meet very often. For the sake of efficiency through the proceeding, I will try to, as the chair of the board, address objections like this as they come. If there's one that seems to me to rise to the level of needing full board discussion, I will do so, but please feel free if you feel like I'm erring on that line, any of the board members, if you feel like ruling on any objections should be brought to the full board rather than me moving them forward to keep the testimony moving, please do so. I think I'm going to rule on this one, but if any board members want to bring it to the board, I'll give you that opportunity now and invite you anytime in the future in this hearing to jump in if you want to bring the discussion to the full board. And not hearing any from board members, I'm going to grant the objection on as I'm going to outline it, my understanding of it. My understanding of Mr. Barker's testimony is that he's applying the reliability standards, that he is not the witness who has testified with respect to the bid specifications. And Mr. Gordon has identified which witness that is who can testify to bid specifications. I don't see anything within the scope of the direct testimony of Mr. Baker that opens him up to questions about bid specifications. but it again seems more focused on the reliability standards of what size line would be needed to meet the need that's being identified. So I'm going to affirm the objection, and so Mr. Gordon, you may move forward with your questions.
Thank you. Thank you. Let me just look through real quick here so I get down to a part that you have not excluded. Let's see here. Okay, Mr. Barker, you state that there are 3 lines that serve the Park City area, one up Parley's Canyon, one up Provo Canyon, and one out of Wyoming Silver Creek line, correct?
Correct.
As it stands today, with all 3 of these lines functioning, Rocky Mountain Power System operates in accordance with the standards set by the American National Standards Institute, correct?
Correct.
But your testimony is that if one of these lines go down, voltage will drop below 90% of nominal voltage on the system, correct?
That is correct. It's more of an issue on the 2 lines, the one up Parley's Canyon and the one up Provo Canyon. It's less of an impact.
So let's talk about those lines. How old is the Parley's Canyon line?
I don't have that information.
Okay. From a reliability standpoint, wouldn't it be important to understand how old that line is to assess its reliability?
Not necessarily.
So the age of the line doesn't really go into your analysis as far as reliability goes.
As far as applying reliability standards, we don't look at the number of outages affecting a line to ensure that we align with reliability standards. We only look at if the outage occurs, what is the extent of the issue that would occur as because of that.
So just to be clear, so in your industry standards, there's nothing that you look at that says a line that's 50 years old is any less or more reliable than a line that's been put in last year.
Well, I think we're mixing things up here. Are you talking reliability, NERC reliability standards? That is true. We do not look at the age or the number of outages, which is what we are expressing here in my testimony. Now, if we are looking at reliability in general, the performance of a line, then yes, we may take that into consideration.
Okay, but in this instance, you have not looked at how old the line is. You're not aware how old the Parley's Canyon line is, correct?
Yes, I'm not aware of that.
Okay. How many times has the Parley's Canyon line gone down?
I'm going to have to look at if that was provided in our outage data, the confidential outage that we applied. Just give me a minute to look at that.
Sure. No, that's fine.
In what we provided, I am counting 15 times that line tripped offline over the last 5 years.
Over the last 5 years, okay. And when we have something that trips, what does that mean?
I haven't differentiated between the two. I would require more analysis of this spreadsheet, but it can mean two things. One is what we call a trip and a reclose, where the fault that occurs on the line is an instantaneous fault, such as a bird or a tree gets in the line, or a lightning strike, something that's very temporary. Our line trips to clear that fault and then recloses and then stays in. And then there's the second, that there's more of a permanent fault, such as structure or conductor issue, where that stays as a permanent fault.
Okay. So just to kind of clarify here, so of the 15, some of those are going to be these temporary ones that would just be like a momentary bump in the system. It would be down for just a few seconds and come back up. Is that correct?
Yes, that's correct.
And then the permanent ones, are you aware of how many of those are permanent outages?
Again, I'd have to look through this. If you give me a minute, I can determine that.
Yeah, if you want to look.
So in my quick review of this, I have identified 5 of the 15 instances that were longer than 5 minutes, which is where we typically draw the line for a sustained versus momentary outage. One of those was construction related. So four of the 15 would be the more sustained faults.
Okay. Are you aware of those permanent outages? Were any of them, I mean, what was the longest outage that was experienced?
This is Mr. Reich. Just so the record's clear, Mr. Barker is referring to the document labeled RMP 139 that was produced in this proceeding.
Thank you for that clarification.
This is Troy Fitzgerald. Since we've been referring to exhibits, I've got volts and midways, but I've looked through everything I've got and I don't have access to Rocky Mountain's exhibit list. Can someone let me know where that is or where it may be locked in my system?
This is Thad LeVar. I will go ahead and forward the email that I received with Rocky Mountain Power's exhibits to you. I'll do that right now.
Thank you.
And Commissioner Fitzgerald, if you need me to stop for a moment, just give me guidance. I want to make sure that you've got what you need in front of you as we proceed forward.
Let's move forward while we're discussing it. Now, if we get to someplace where I'm hung up, I'll pipe up. Thank you.
Sounds great. Thank you.
again, quick calculations, I'm showing about 15 hours was the longest.
Okay, so there was one outage for 15 hours, and other than that, the ranges on these from 5 minutes to 15 hours, is there a way to just let us know? I mean, did they range from 5 minutes?
Yeah.
Were there a bunch for 2 hours? I mean, what did we have?
One was about 3, 2 were about 6.
Okay, so 2 that
And
were
the construction one was well over a week.
Okay, but that one you knew was coming, correct?
Correct.
Okay. Okay, very good. In your experience, have you ever known this line to go down for longer than 24 hours?
No, I would have to go back and look at the history. I know around the time of the Olympics, there was an issue with a helicopter in that line. I'm not sure what, that was a major outage, but I'm not sure of the time frame on that.
Okay, all right. Very good. Now let's move to the Provo line. How many times has the Provo line gone down?
Four times?
Okay, and of those 4, how many were temporary?
Two.
And the other 2, how long were they out?
One was 8 hours. One was approximately 37 hours.
37. On the 37-hour one, what happened?
There was a mudslide in the canyon that took 2 structures out.
Okay. Very good. Now let's turn to the Wyoming line. How many times has it gone down?
Eight times?
And of those 8, how many were temporary?
Six of the 8.
And the 2 that were permanent, how long were they?
About 1.5 hours and 1 hour.
Okay. Just a quick question going back to the Provo line. If the Provo line goes down, it primarily hurts Heber Light and Power, correct?
That is where the issue is the worst, that's correct, but I don't think it's a correct statement to say it primarily affects Heber Light and Power.
Okay, but currently in the system, there's no transmission line that connects that Provo line over into Park City, correct?
No, that's not correct. There's a 46 kV line that connects our Midway substation into the Park City area.
Okay, so if the Provo Canyon line goes down, you still have two lines serving the Park City area, correct?
We have the two 138 kV lines that serve that area. Yes, that's correct.
And you can reroute those if the Provo one goes down to serve your clients over in Park City, correct?
No rerouting would be necessary. I don't understand that question.
Or maybe I'm just not using the correct term. I guess if the Provo City line or the Provo Canyon line goes down, you still have adequate capacity to serve all of your customers over in Summit County, correct?
No, that's not correct.
Okay, explain to me why it's not.
Well, as we discussed in my testimony, the issue here is that the voltage in various locations in the Park City area and primarily in the Heber Valley area would go below our guideline, and we anticipate blackouts due to that low voltage throughout the Park City area initially.
So let me just read this so that I make sure that I understand it. So there was a question in your written testimony that says, if either the Hale Midway or Cottonwood Snyder 138 kV transmission lines experience an outage, couldn't Rocky Mountain Power System operators switch the power to come from alternate sources? And you answered, all available transmission sources are being utilized under this scenario. Switching by Rocky Mountain Power System operators would enable the restoration of all but 42 megawatts of customer load, which would raise voltages above planning standard limits. So based on that answer, my understanding was that if the Provo line goes down, you would have sufficient to continue to serve through the other two lines and still meet your planning standard limits. Is that correct?
That's correct. What I mean by switching here is that we would be opening circuit breakers throughout the Park City area, taking that 42 megawatts of power offline to enable that. So there would be what we would consider rolling blackouts to keep the loading to that 42 megawatt level.
I see. Okay, and that helps me understand what it was your testimony was there.
So in context as well, that what that 42 megawatt level is that's the entirety of the Heber Valley area is pretty close to 42 megawatts plus some of the Park City area.
Okay, I'm trying to just make sense of what I just heard there. So let me just give some thought to that. I think I understand kind of what your answer is, and I appreciate your clarification on that. So let's move forward. The situation with the three lines in this area, how long have those three lines been serving this area?
Well, this goes back to when those lines were constructed, and I'm not sure when the Cottonwood and the Cottonwood line and the Midway line up Parley's Canyon and up Provo Canyon, those have been in service for many years, decades. We somewhat recently finished the railroad to Park City line. And I'm not exactly sure the year, it was 2016 or 2017.
So that one's new. The other two go back, 20, 30, 40 years, something like that, just to kind of to give us a sense of how long they've been there.
Yes.
Okay, thank you. In the amount of time that these lines have been in place, how many times have there been blackouts in the area that these lines serves?
For the 5 years that I looked at the outage history in detail, we did not have any blackouts.
Okay, and to your knowledge, prior to this, have there ever been situations where the system was damaged so bad that you had rolling blackouts in this area?
Not to my knowledge. There have been outages to this area due to transmission issues, but not the rolling blackouts that we're talking about.
Okay, thank you. And from what I understand, the longest outage in any of these lines right now is 37 hours due to a mudslide, correct?
Correct.
Okay. Do you know how many times there's been damage to Rocky Mountain Power's equipment due to the loss of load or one of these lines going down?
I'm not aware of any.
Okay.
You said Rocky Mountain Power equipment, correct?
Yes, Rocky Mountain Power equipment. Yes.
Yeah, I'm not aware of any.
Okay. What is the longest any customer has been out of electrical service due to the loss of one of these transmission lines?
I don't have that information.
Okay. Is it safe to say that 37 hours would probably be the longest that you're aware of?
So just to clarify, no Rocky Mountain Power customers were out of power during that 37 hours.
Okay. So, I guess, so that's my question. Of the ones that we've already talked about on all three of these lines, has there ever been, what's the longest you're aware of that Rocky Mountain Power customers would have been out of power?
Due to these outages, I don't show any Rocky Mountain Power customers being out of power due to these contingency outages that we're talking about.
Okay. So, is it safe to say that the current system, based on at least the last 5 years and your knowledge, pretty reliable, hasn't had a lot of problems, correct?
That's correct.
Okay. Can you tell me how do I say this? How likely is it statistically that we're going to have an event on one of these lines if we extended building this new line until the spring of 2021? How likely is it that we would have an occurrence that would result in Rocky Mountain Power losing customers not being able to receive power?
You're asking me to speculate on whether a catastrophic issue is going to occur in our lines either this year or next year, and I can't speculate on whether that is going to occur or what the probability of that is going to occur. What I can tell you is that the number of hours where we will have voltage issues, if it does occur, is increasing every year and the longer that we wait.
Fair enough. And so short of a massive catastrophe that obviously none of us can predict, do you foresee in just the normal operation of these lines what the additional risk would be if the line does not go in until the spring of 2021?
Next year, we're projecting 620 hours of risk over the winter. And for the following year, there would be an additional number of hours added to that. And I think that the likelihood, given that we had a mudslide in 2017 that took out some structures, now if that had occurred a few weeks earlier during our peak, then we would have had Rocky Mountain Power customers out of power. If there had been adverse weather conditions that precluded us from getting into the area, then that would have extended the outage. If it had occurred in an area where we needed helicopters to repair the line, which there are many areas in both of these canyons where that is needed, then we would be extending that 37 hours by quite a bit. So to say that it's not likely or it's nearly non-existent, the probability of this occurring is just not accurate.
Okay. But isn't it fair to say that in the history of this line that you're aware of, there's been one catastrophic event that's called a mudslide, a catastrophic event in the 20 or 30 years that these lines have been operating?
In the last 5 years, that's correct.
Okay, and you're not aware of any others in the time frames before that?
Other than the helicopter issue that I just mentioned, I'm not aware.
Okay, thank you. Midway City's been told repeatedly that the new line must be finished by the end of 2020. Is that coming from you?
We advocate getting this project done as quickly as possible to mitigate our risk of an outage occurring and affecting our customers in the Park City planning area. I've been personally working on this project since 2011, 2012. It's been in our budget since 2017 and been pushed back multiple times. So we are an advocate of getting this done as quickly as possible to mitigate that risk that I just discussed.
Certainly. And the risk that we are discussing has been in place, probably increasing annually, but it's been in place for many, many years prior to right now, correct?
Very minimally. They show that in 2011, we had very minimum risk, maybe a few hours a year. In 2017, we completed what we call our Snyderville project, which substantially increased that risk and the number of hours of exposure, which is why, from a planning perspective, we recommended that become a budget item in 2017.
Okay. Let me just look through my questions here. So basically, based on your testimony, right now, and I understand you're looking out and you're trying to deal with potential problems, but really the threat that we're talking about here is based on what could happen to the line, correct? But statistically speaking, it's probably pretty minor that something like that could happen in an additional 5 months given the history of the line, correct?
I can't, like I said, I'm not going to speculate on whether a mudslide is going to take out our line. It has happened in the last 3 years, and so I don't know what you mean by statistically, but in my view, it's probable. In Rocky Mountain Power's view, it's probable. If that does occur and there are rolling blackouts in the area, it is Rocky Mountain Power that is going to be held accountable.
Fair enough. What is the useful life of a transmission line once it's installed?
We don't have I wouldn't say we have a specific time frame. We maintain our lines. We replace poles as needed. So useful life is as we can keep it maintained and running properly.
Okay. Is it reasonable to assume that once this line goes in, it will be there for the foreseeable future, meaning decades and even centuries?
Yes.
And once the line goes in, Rocky Mountain Power wouldn't have any plans to ever remove it, correct?
Not unless we were requested to put it underground or relocate it, which often entities do.
Okay. And so I guess the delay of 4 or 5 months, if that's what it takes to get a bond, would be really kind of a small percentage of the entire life of this line, correct?
Yeah, that's correct.
Okay. Just a couple more questions here. If complications occur within Heber Light and Power's system, those don't affect Rocky Mountain Power once the new line goes in, correct?
Sorry, can you repeat the question?
Sure, and let me explain it maybe a little better. My understanding is that once this interconnect happens, that Rocky Mountain will be able to wheel power back and forth on its own line, regardless of whether there's any complications within Heber Light and Power system. Is that correct?
Yes, that's correct.
Okay. So if there is a problem in Heber Light and Power system, that will not interfere with Rocky Mountain Power's capacity to provide service to its customers over in Brighton, Deer Valley, or Park City, correct?
Correct.
Okay. This, I'm just going to ask, as I'm thinking this through, it seems like if one of the lines go down, is it fair to say, for example, if the Provo line goes down, the entity that would really face the biggest brunt of that will be Heber Light and Power, correct?
No, I think it would be Rocky Mountain Power and its customers, one of which is Heber Light and Power.
But primarily that line up Provo Canyon serves Heber Light and Power, correct?
Defined primarily, it's a certain percentage, probably majority percentage of megawatts being served, but this is a system. It's all interconnected. It's all looped. The system itself, that's just one of the customers. The issue that we're talking about is it's just a system issue. We don't just we call it a radial line that just serves them off of this line. It's all interconnected and it supports each other.
Okay, but the loop has not been completed at this point, correct?
Now, like I said before, there is a 46 kV loop that allows the Midway transformer to stay energized if there is a issue on that line. It's just during certain numbers of the year that line cannot support the load. And so that's why we're proposing this loop through on the 138 so that we have that support.
Mm-hmm. All right. I guess the point I'm trying to make here, or trying to understand, is if Heber Light and Power were willing to push this out and allow Midway City to bond, wouldn't they really be the entity that's taking the biggest risk if something goes down?
No, I don't believe that's the case. I think Rocky Mountain Power is taking the biggest risk. It's Rocky Mountain Power's customers. Heber Light and Power is one of those customers, and we have other customers in the Park City planning area that would be assuming that risk.
Well, and let me understand that. Aren't the two lines coming over into the Park City area, and maybe a misunderstanding, aren't those sufficient to deal with the needs of Park City, even if the Provo line went down?
As I discussed before, it's adequate for all but for 42 Well, the entire load minus the 42 megawatts. And so 42 megawatts would be in a rolling blackout stage in the entire Park City area. As I understand, we would operate in that condition.
Okay, that helps me understand. I appreciate the clarification there. Let me see here. If there's anything else. No, I think that's everything. Let me just look through. Give me just 1 second here. So let me ask just one other question here, and then we're almost done. When we talk about in your testimony that there's up to 620 hours of exposure to the risk of inadequate voltage, what does that mean?
It means the voltage on at any substation bus that we looked at would be less than the 0.90 per unit, which is 90% of normal voltage. So think of that in your house, it would be 90% of your 120 volts.
Okay.
That's just applied to the transmission side. That it's not necessarily applicable on the customer side.
Okay. And so on those 620 hours of exposure, I'm trying to understand what that means. Like, for example, as we go back through and talk about the history of these lines, where most of that exposure, it sounds like, would be temporary outages. I mean, how do you calculate what exposure is?
So there's a certain load level, and what we've identified that in some of our documents. So once the load level in the Park City planning area, which includes Heber Valley, once the load level exceeds 175 megawatts, then we have the risk of the voltage in the area going below 0.9. And so we just sum up the number of hours that we project the loading to be above 175 megawatts. And it varies. I think in what we forecasted for this next summer or next winter is 217 megawatts.
Okay.
So the load will vary between 175 and 217, but the number of hours that varies between there is 620.
Okay. And on those hours of exposure to the risk, if it does drop below 90%, that doesn't mean that you're completely out of power, correct?
For some customers, that's not the case. If the voltage drops below 0.9, it is likely that some of our customers' motor load would trip off to prevent damaging their equipment.
And that would be like a Heber Light and Power customer, a transmission partner, not an end user, correct?
No, this would be any end user.
Okay. And how far, I mean, if it dips down to let's say 85%, and then comes back up, I mean, what impact does that have on the system?
Just to clarify, which system are you referring to?
Well, I think the entire system, not Heber Light Power's Rocky Mountain Power system.
Like I just previously stated, customers protect their load from low voltages. In an ideal world, sometimes they don't, and then equipment damage can occur. But if they are protecting their devices, when the voltage goes below some of these levels that we're talking about, their load trips off. In particular, their motor load, and perhaps some of their electronics that's not designed to operate at those lower voltage.
I see.
So we would not have devices that opened up, but the customer equipment would most likely start to trip itself offline to protect itself from the low voltages.
I see. And how difficult is it to reset those once they're tripped off? Is it just like your standard home, what do you call those? Your breakers, where it kicks it off, you go and turn it back on when it comes back on?
No, I'm not an expert on what customers' particular loads are going to do. My speculation is once the voltage recovers, then it would be able to restart. There may be a cooling off period before they could restart some of their motors.
Very good. And based on your current customers that you would be concerned about, what percentage do you think would not have the protections that we're talking about as far as their system automatically tripping off if this happens?
Again, that would be complete speculation on my part. I don't have a reasonable response for that.
Okay. Is it an industry standard though, when like homes are being built and these types of facilities are being built, that they have to meet a certain, they put in safety measures to protect against this?
That's a function of the equipment that's being operated, not necessarily the homes that are being constructed. I would say that most do have that protection.
Okay. I think that's all the questions that I have. Oh, I'm sorry. Go ahead. You can finish.
I was just going to say that the question here is that the load is coming offline, not necessarily that the equipment will be damaged. And that was reflected in my testimony. The equipment may be damaged, depending on that would depend on what they have for protection.
No, that helps. That helps. Okay. I think that's all the questions that I have for this witness.
This is Thad LeVar. Thank you. I think it'll be appropriate for us to take a break now before we move to any questions from Volt for this witness. But before we take a break, just so I can use my time during the break the best, Mr. Wright, you had indicated earlier on, you told us the order of witnesses, and I didn't get it jotted down as you were stating it. Can you repeat for us again the order in which you intend to call your witnesses after Mr. Barker? If that's firm and not fluid. If it's fluid, tell me. But if it's set, it would be helpful to know.
Yeah, we intend on calling Ben Clegg next, and then Darren Myers.
Okay, thank you. That's helpful to me. I think what we'll do is we'll go ahead. Yeah, who's speaking now?
Dave Clark.
Yes.
And if I could take just a second to express something I anticipate doing that might bear on counsel for Midway's cross-examination. I have, and I'm harkening back to the objection that was sustained regarding construction specifications, and I was a little confused by the questions and answers at that stage, and I want to express at least my feeling that I'm interested in knowing to what extent the construction specifications were influenced by reliability requirements or requirements to meet reliability standards. Thinking in particular of redundancy requirements that exist in the standards that are promulgated by the Western Electric Coordinating Council and North American Electric Reliability Corporation. So I think I got an understanding regarding the dual trenching, and but the other at least the one other major expense item, the deadline requirement. I understand that's I'm uncertain whether that's a construction specification or is driven by reliability standard. But if it is a reliability standard, and if Mr. Barker's the witness to address that. I intend to ask him about it, but I didn't want to do that and then open an area of cross-examination that Midway's counsel may have felt precluded from addressing. So that's the sort of issue that I wanted to present to you.
And Commissioner, this is Corbin. As far as responding to that, I did have a line of questions, and I assumed that Mr. Barker was the appropriate one to talk about that issue. And so I skipped those based on the ruling from the board. But it sounds like Commissioner Clark was on the same page with me. I thought this was the appropriate witness to answer those questions.
So this is Dave Clark again. If he's not, that's fine. But if he is, I didn't want to foreclose you from your opportunity.
Okay, anything else, Mr. Clark? Okay, we'll be in recess until 1 o'clock. And before our lunch break, we had preliminary concluded the cross-examination by Midway City, and then one of the board members, Mr. Clark, raised the issue of revisiting the ruling on the objection by Rocky Mountain Power. The previous ruling was that questions regarding bid specifications were outside of the scope of Mr. Barker's testimony and were within the scope of Mr. Meyer's testimony. We have a request by a board member to revisit that ruling on the objection. So before we move on to Volt's cross-examination, I think it would be appropriate to address that issue with the board at this point. So I'll ask if there's any board discussion to that issue.
Well, Chair LeVar, this is Board Member Jordan Weiss speaking. I guess, from my perspective, I am also interested. Let me just take a step back. I think when we're talking about, and this happens a lot in this business, but we're talking about reliability in terms of, capital R reliability. That is a NERC standard, which is probably a little bit different, at least from my perspective, what the witness was speaking to, which is power quality, which is things like, wavelengths, voltage stability, that kind of thing, how power quality actually works with respect to customers and, driving crankshafts for ski resorts, on their lifts, et cetera, like that. I guess what I would suggest is if there's another witness that could speak to actual reliability standards, in other words, NERC, federally, delegated standards in that kind of world, I would be interested in hearing that at some point. But I guess the question is it possible to maybe allow the other witnesses to be cross-examined and to address their issues? And then at the end of all of the witnesses, if we have still not, scratched that itch, in other words, addressing how NERC standards flow into specifications for this line, then we could go back to this witness. I guess what I'm trying to say is I'm not sure if we're going to get what we want out of that witness, because I think he's already addressed power quality issues, but I could be wrong, but that's just a suggestion.
This is Dave Clark. Let me just confirm. I think Mr. White has described what I'm trying to get to, and that is the extent of any relationship between reliability standards that Mr. Barker applies and the bid specifications. Is there linkage? In particular, and he's addressed the dual conduit or the dual trench bid requirements. I also had in mind the dead cable specification, and I'm wondering, does that have any reliability standard underpinning?
And let me just respond to Mr. Clark. If that is I thought that had been answered, but if he hasn't and there is a relationship, I would like to hear that also. I thought that was answered, but if there's a direct relationship between those two, that would be helpful. And maybe I missed that, but I thought that he had answered that already. But if that's the case, then perhaps that's a worthwhile question right now.
Chairman, this is Brett Reich with Rocky Mountain Power. Can I just add something that might help clarify this and move it along?
This is Thad LeVar. Yes, that would be appropriate.
So I think that Mr. Barker is able to testify about reliability as it relates to NERC and the relationship of reliability as applies to bid specifications generally. My objection was really focused on these bid specifications as, did they have some specific reliability standard? Because our bid specifications are based on engineering standards that our specification group creates for all of our projects. There's not some reliability standards for this project and some for a different project. So we have no objection to Midway City asking him about reliability as it relates to NERC or the relationship of reliability to our bid standards, generally speaking. So we have no objection to that.
So this is Thad LeVar again. It seems like, is there any objection from the board to returning to Midway City before we move on to Volt to explore this issue a little bit further? I'm not hearing any objection from board members. So I think we'll go forward that way. So, Mr. Gordon, if you have any further questions on this topic that you would like to ask this witness, please go ahead.
Certainly, thank you.
I forgot to confirm that Mr. Barker was on the line. Are you on the line, Mr. Barker?
Yes, I'm still here.
Okay, and you're still sworn in from this morning. Thank you.
Perfect. Thank you. Okay, so Mr. Barker, just a few more questions then. And as I understand it, I'm not going to be referring to specific specifications, but more generally, in this instance, when you're burying a line, my understanding is it is common to put an extra conduit as part of the buried project. Is that correct?
I can't speak to what's common in the industry. That would be more of an expert in our construction standards that would be able to talk.
Well, is there a reliability aspect of putting in the extra conduit?
Yes, absolutely.
And what would that be?
Well, the failure of an underground line can take several days to weeks to repair, depending on what the issue is. We don't have the expertise to do in-house to do splices, and so that needs to be brought in from outside the state typically. There's other issues with pulling that can arise from pulling in the new cable, and so it is more reliable for us to have a conduit and cable in place so that we can energize that on a much quicker basis.
Okay. Are you aware of any NERC standards that require a dead line to be pulled through that conduit?
I'm not aware of any, no.
Okay. Are you aware, has Rocky Mountain Power buried other 138 kV lines?
Yes.
And were you involved in those projects enough to know what happened on them?
No, not from a detailed construction standpoint.
Do you know, is it your recommendation from a reliability standpoint, does Rocky Mountain Power have a standard when they're putting these underground to leave the conduit open or to pull an extra line?
It's my understanding that we pull up the extra line.
And does that come from you as the director of the Power of Quality and Reliability?
No, as I said before, those standards are set up by our construction standards engineering group. Our planning department may provide input, but those construction standards are built by that department.
Okay, so really the extent here is that you're not aware of any NERC requirement that requires that to go through, correct?
Correct, but the underpinning of that requirement that we have is to mitigate the risk of the NERC requirements. So in this case, if the NERC requirement may say that we have an N-1 or a single contingency outage that causes an issue, and that we need to plan for that. If that cable fails and it's out for 2 months during the winter while we're trying to repair it, then we're in the exact same condition we are in today and that we've been discussing.
Do you have any knowledge or understanding on how long it takes to pull a new line through if the cable were, or if the conduit was empty?
Are you saying if the conduit is empty to get the cable in?
Yes.
Yeah, I don't have any specific details on what that would take. Like I said before, if there are splices involved within this case over a mile, there would be splices involved. I know that we do not have in-house expertise, so that needs to be scheduled and flown in. And it does take time to perform those splices. In addition, As I understand it, some of the cable needs to be ordered. We do have some spare cable in our inventory, but that might be an issue too on the timing. We might need to, we might have to bring in additional cable for that. So I don't know an exact time, but it isn't, it isn't a couple of days, probably a couple of weeks at least.
Okay. And having the extra, having that extra deadline sitting there, it doesn't alter in any way the reliability of the energized circuit, correct?
Not that I'm aware of.
Okay, no further questions.
Okay, thank you, Mr. Gordon. Mr. Morris or Mr. Brereton, you have any cross-examination questions for Mr. Barker?
I do. This is Mr. Morris. Thank you. Mr. Barker, good afternoon. During the break, did you have a chance to discuss your testimony with anyone other than counsel?
No.
I'm going to try hard not to replow ground that was already covered. But what I understood you to tell Mr. Gordon is that although the three lines that you and he discussed and the downtime for them being respectively, I think 8 for one, 5 for another, 15 for another, in all of those cases, no one ever lost power in their homes, right?
This is referring to the outages that we've discussed?
Yes.
To my knowledge, no.
Okay. So because Rocky Mountain has built redundancy into the system, you're able to switch over when a line goes out and maintain coverage for your end users, correct?
No, that's not correct. During certain times of the year and above certain loadings, that is not correct, which is what this project is predicated upon.
Well, I'm not asking you to speculate about the future, but in the past, I understand your testimony to be that has not occurred, that the situation arose where you were not able to switch and cover for a line going down, for example, the helicopter or a mudslide or whatever you referred to.
It is my testimony that that situation has not occurred. However, it is my job as Director of Planning to plan for situations that can occur, which is what this project is all about. A catastrophic issue could cause rolling blackouts and serious issues in Heber Valley and parts of the areas.
It's fair to say that if a line is underground, it's less at risk from a helicopter hitting it and interrupting it, isn't it?
Perhaps, but we still have overhead components, such as the dip poles that are still in the exterior line of risk.
Well,
but that line, let me clarify this though. That line that is being underground is not part of the line that causes the issue. The line that causes the issue that we're discussing is 100% overhead, and it is not being modified in any way as part of this project.
So it sounds like you're saying reliability really isn't a factor as far as this line goes. That you're worried about bad things happening elsewhere, right?
This line is the solution to bad things happening elsewhere.
But let's by this line, I'm only concerned with the mile or so going through Midway. If that line goes underground, at least that portion of the line is not going to be subject to many of the problems that you've described as being at risk on other parts of the line, like mudslides, weather, helicopters, things like that. Is that fair?
That's fair. My point that it's irrelevant to the issues in the area.
Okay. You just mentioned that you have buried transmission lines in the past. How long have you been in your job, Mr. Barker?
I've been in the director of area transmission planning for 2 years.
And your total duration with Rocky Mountain Power is how long?
17 and a half years.
Were you involved at all in the underground transmission line that was built along 39 South from 9th East down to Main Street a few years ago?
No, I was not.
Were you involved at all in the transmission line that was buried out in Draper from Dimpledale Road down to about 10th East?
No, I was not.
Are you aware of those lines?
Yes, I'm aware of the lines.
Okay. See. Are you involved in regional transmission study planning at the Western Area Coordinating Council?
We are involved, my department is involved as a support role. Like I testified earlier, our main grid transmission department takes the lead role in that compliance effort.
And so, to what extent are you involved in Pacific Corp's transmission planning for its integrated resource plan?
Very little.
Do you participate in system impact studies that are run for transmission service requests pursuant to Rocky Mountain's open access transmission tariff?
Yes, we are involved with those system impact studies, depending on the voltage.
So, would you have the ability to tell us then what portion, if any, of construction costs of 138 kV lines will be recovered by Pacific Corp through rates charged under its OATT?
I'm not in a position to talk about rate recovery.
Do you know if any of the other witnesses coming on are going to be in a position to tell us what portion of the construction costs that Rocky Mountain is saying it will incur are going to be recovered elsewhere?
I'm not aware that these witnesses have that expertise.
Can you tell me, Mr. Barker, is there any portion of this Heber to Midway line that is considered a network upgrade?
It depends on how you define network upgrade. We have a Rocky Mountain Power definition for that, and we also have a definition of that under the OAT, the transmission service request that's being made by Heber Valley, and I would not be in a position to answer to either of those.
And so would you agree with me that Rocky Mountain would not be entitled to charge monies for construction or assign costs that are attributable to network upgrades under either definition?
I don't know if I understand the question.
Well, please explain to the board the two definitions of network upgrades you just provided me.
Well, I just know that there's the distinction between the two. I don't believe that I'm in a good enough position to define those for the board.
And you don't know, Mr. Barker, if what portion, if any, of any costs that Rocky Mountain would try to claim to be excess costs that Midway is going to have to come up with are due to a network upgrade rather than installing this line.
Like I said, I'm not in a position. I can tell you what I think, but I just don't think that I'm in that position to distinguish between network upgrade, and there are probably better witnesses for that discussion.
Who are any of those better witnesses in the queue that you're aware of?
Not that I'm aware of. I haven't seen network recover or network upgrades in any of the direct testimony that we've submitted or in rebuttal, so I'm not sure.
And that's the reason for my question. I'm not seeing it either, but I'm wondering if Midway is being expected to pay for a network upgrade. You don't know the answer to that.
Well, I don't believe that Midway would be expected to pay for a network upgrade.
Well, I don't either. I would agree with you. But it doesn't sound like you or any of the other witnesses we're going to hear from can say unequivocally that among the costs being claimed by Rocky Mountain to build, to go underground, for example, whether any of the line called out by the specs and bid on by these contractors can be characterized as a network upgrade.
That's correct.
All right. Looking at my notes here. You're not going to have a deadline on the overhead towers, are you?
Can you clarify the question?
Yes. Mr. Gordon was asking you about this extra conduit and a line being pulled through and asking Midway to bear the expense of that. A line that isn't going to be energized. This is going to be lying there for an emergency someday. And my question is, there is no such line contemplated currently on if this goes overhead. Is that you're not going to be stringing deadlines on these towers if you go overhead, are you?
Yes, that's correct. That's related to the time to repair, the accessibility on the overhead, and the materials to do it are not, they're not time constrained.
Would you agree with me that the likelihood of an underground line going bad is a lot lower than if it's exposed and in the air with birds and helicopters and weather?
Well, with underground lines, it's a trade-off, and by and large, I believe that we're agnostic between overhead and underground. The trade-off is that there may be fewer instances on the underground. When they occur, they last much longer, as opposed to the overhead where they're more frequent. But again, as it relates to this issue, that line outage is not relevant to the issue at hand.
So all right. I think that's everything I have for you, Mr. Barker. Thank you.
This is Thad LeVar. Thank you, Mr. Morris. Mr. Reich, any redirect?
Yes, thank you. Just a few. Mr. Barker, in your direct testimony and in cross-examination, you mentioned that you have some concerns about the outages of specifically two of these lines that go up to the Heber Valley area. Can you provide a little more detail about some of those concerns with respect to repairs or access?
Sure. I mean, we can try to paint a worst case scenario, which I think is a reasonable thing to do in the position of planning that we are in. And the 138 kV lines that run up those two canyons are in very difficult terrain. The accessibility is very difficult, especially in the winter. There are issues with avalanche concerns. So if we did have an issue with one of those lines where a section of the line or even a single structure had an issue, we would have difficulty getting personnel to that location, for one, just to perform any repairs. It's likely that we would have to bring in helicopters that may need to be brought in from a regional or national basis. So there's time that we need to get those materials and equipment to the site. I just can't reiterate enough. I don't think that there's significant risk in these canyons for a prolonged outage if the right set of circumstances occur, which is why we are, being very, strong-willed about getting this project done and trying to mitigate that risk.
So based on your understanding of the Rocky Mountain Power transmission system, is this project necessary to permit Rocky Mountain Power to provide service to its customers in a safe, reliable, adequate, or efficient manner?
Yes, absolutely.
I have no further questions.
This is Thad LeVar. Thank you, Mr. Reich. Mr. Gordon, any recross?
No, Your Honor.
Okay, thank you. Mr. Morris, any recross?
Just so I understand, yes, just one question. The things you're trying to guard against and your particular concern about these two lines, neither of those issues are any more or less likely to occur in the next 5 months than 10 years from now, based on what you know, correct?
Again, I'm not going to speculate on the probability of any natural event, something beyond our control, occurring within the next 5 months or a year. I don't have that capability.
That's all. Thank you.
Okay, thank you, Mr. Morris. Mr. Clark, do you have any questions for Mr. Barker?
Yes, just a couple. So, Mr. Barker, from your answers, am I correct in understanding that the reliability standards you apply are expressed in or expressed as electric system attributes rather than construction characteristics or construction criteria?
Yes, when we look at NERC reliability standards, we just look at outages as occurring on the lines as an entity with no other parameters like age or performance of the line. None of those things are taken into consideration for NERC reliability standards.
So when you identify an issue, as you've done in this case, then again, I have the impression that you hand that off to another department that then applies, that from an electrical engineering perspective creates the solution to the issues that you've identified. Is that how the process works?
No, not necessarily. We in the planning group, we develop the scope of the project from a high level, and then it is passed to an engineering design group, and then it would then apply our construction standards and come up with an actual design of the line. So we're talking about this, the number of structures, and how it's constructed.
Yeah.
We specify
Okay, well,
the capacity that is needed and basically where it connects to.
yeah, thanks for that clarification. So those are all the questions I have.
Okay, this is Thad LeVar. Thank you, Mr. Clark. Mr. Fitzgerald, do you have any questions for Mr. Barker?
This is Troy Fitzgerald. I do not.
Okay, thank you. Mr. White, do you have any questions?
No question, thank you.
Okay, Mr. Wright, do you?
Yes, I do. Last summer, the public officials in Summit and Wasatch County, both the county and city level, were briefed on a program called the Public Safety Power Shutoff Plan. And mostly we were told that it affected the distribution systems in our jurisdictions. Their power lines could be shut off under high rain and low relative humidity conditions during summer wildfire season. Do any of these three transmission lines, will any of those three be affected by that same program?
Yes, they are. I'm not positive on the railroad to Silver Creek line, but the other two lines are within those areas.
Okay, so under certain weather conditions, both the Carly's Canyon and the Provo Canyon lines could conceivably be shut down for safety
sorry.
reasons.
I hate to interrupt here, but I'm having a really hard time kind of hearing you. This is the reporter. Not
Okay.
Liz. I'm having a harder time hearing the question by Mr. Wright.
Okay, can you hear me now?
Yes, maybe just slow down just a little bit. And yeah,
Okay,
just you're clear.
I will do so.
For some reason, it's grabbing some static as you speak. So,
Okay.
okay, thank you.
Okay, my question concerns the power safety, power shutoff plan that was presented to counties and cities in the Wasatch back last summer. And to what extent do the transmission lines, are they affected by that particular plan?
Yes, the Hale to Midway line and the Cottonwood to Snyderville line, both canyons are affected by the PSPS.
Okay, thank you. That's all my questions.
Thank you, Mr. Wright. And Mr. Barker, thank you for your testimony today.
Thank you.
Mr. Wright, you intend to call Mr. Benjamin Clegg next, is that correct?
Correct.
Okay, why don't we address Midway City and Volt's objection to this witness now? Why don't we go to Mr. Gordon or Mr. Jukes first? We have the objection in writing on this one. If there's anything you want to add verbally before we consider this, why don't you go ahead and do so now?
Hello, excuse me? Are you waiting for Rocky Mountain Power or for Midway City?
Okay, this is Thad LeVar. I had asked Mr. Gordon or Mr. Jukes if they wanted to provide any additional verbal comment on their objection to the testimony of Benjamin Clegg.
It sounded like there was maybe someone hit the off button instead of the mute button, so I'm assuming they might be dialing back in. This is Brett Reich with Rocky Mountain Power.
Okay, thank you. Is anyone from Midway City on the call right now? In that case, Mr. Reich, I suspect you are correct in what happened, so hopefully they'll dial
I'm
back
sorry,
in.
we just got, I pushed the wrong button. Sorry, guys. Josh was here making the presentation and we pushed the wrong button. Can you hear us now?
I can hear you now, thank you.
Okay, I apologize. I won't push that button again.
So did none of that come through?
We have not heard anything from you on the objection to Mr. Clegg.
All right, sorry, I just made the argument, and I guess we pushed the wrong button. I apologize. This is Mr. Jukes, by the way. I'll be making the objection quickly. Mr. Clegg, as we've read from his direct testimony, it looks like he's being offered to testify regarding the conditional use permit application process and certain communications between Rocky Mountain Power and Midway City. Mr. Clegg was directly involved in that permit application process. He attended the hearings. He was there for the grant of the permit itself. We believe this testimony is irrelevant to any material issue in dispute. There's no question that the conditional use permit was granted, and all the parties have proceeded under the CUP since then. So there may be disputes about Rocky Mountain Power's need for a separate line, as Mr. Barker testified about, and the actual excess cost of the line, which will be talked about later. But testimony about the application process itself and communication with Midway City appear to be immaterial and, quite frankly, wasteful of everyone's time. We just ask that Mr. Clegg's testimony either be excluded in its entirety. We don't think he's a necessary witness here, or that it be limited to issues that may be relevant.
Okay, this is Thad LeVar. Thank you, Mr. Jukes. Mr. Morris or Ms. Brereton, do either of you have anything to add to the objection?
We don't. We joined in the objection, but I have nothing further to add. Thank you. This is Mr. Morris.
Thank you, Mr. Morris. Mr. Wright, do you want to address this?
Sure, thank you. Yeah, the testimony of Mr. Clegg is being proffered as Mr. Clegg was the project manager of this project. He personally attended the several public hearings and also non-public meetings with Midway City. During that process, there was quite a bit of information that was provided to Midway City, including information regarding right-of-way, regarding the cost, an estimate of an underground transmission line, a feasibility study, many of the documents, many of the things that the Midway City has brought up, and Mr. Clegg has personal testimony about that information and those documents. It also goes to this entire process that Rocky Mountain Power has had in pursuing this conditional use permit. And under Administrative Code 63G4206, the purpose of this hearing is to obtain full disclosure of relevant facts and to afford all the parties reasonable opportunity to present their position. Mr. Clegg is an important part of Rocky Mountain Power's position in applying for and receiving the conditional use permit, which is at issue in this case. So for that reason, we would ask that the board deny this objection and allow Mr. Clegg to testify.
Okay, thank you, Mr. Wright. And I have failed to go to board members, so for both the comments by Mr. Jukes, Mr. Morris is joining in that, and Mr. Wright, do any board members have questions for any of the three of those, with the understanding that I'll probably go back to Mr. Jukes at the end if he has any final wrap-up. But let me see if any board members have questions for any of them, please jump in and ask them now. I'm not hearing any questions from board members. I do want to ask Mr. Reich, you had indicated, I think you said in your statement just now, that the testimony of Mr. Clegg is similar to issues raised by Midway City in this proceeding. Do you have any examples you could point to of that?
Yeah, for example, I know that while Mr. Clegg was the project manager, there was an underground transmission cost feasibility study that was prepared and submitted to Midway City. Mr. Clegg has information about that cost feasibility study. He also has information about the information requests that were given to us by Midway City, how we responded to those, what was provided. Some questions that were asked about the value of right-of-way easements and our evaluation of those easements. So he can testify about those things.
Okay, thank you, Mr. Wright. I'll just give one more moment if any board members have questions. And I'm not hearing any, so we'll go back to Mr. Jukes if you want to give any final comments on your motion. And I especially ask if you could address whether you consider any of the testimony about the history of the application process to be prejudicial to Midway City at all.
And I think you've hit the nail on the head. I don't think it's prejudicial. I'm just trying to avoid a waste of time and streamline these proceedings. And maybe you've already spent too much time talking about it. I think the things that Mr. Wright just mentioned, Mr. Clegg may have knowledge about those things, but it's not in his direct testimony. I wouldn't object to him testifying about some of those things. What I don't do is spend a couple hours talking about, the first application and all the hearings. And Mr. Clegg was there, I was there. He's a great guy, but none of that's relevant here. Not that it's prejudicial. It's just, I think, would be a waste of time because we all admit that the CUP was actually granted and it says what it says.
Thank you, Mr. Jukes. Does any board member have questions for him at this point? I'm not hearing any board member questions. I think on these objections to witnesses, I think all of these ought to be board decisions. So let me just ask if there's any board discussion or thoughts on the motion in front of us, or the objection. I will just state my one thought as I've been listening to the discussion is I understand the issues that are in dispute, and I understand the point that perhaps the application process is not in dispute. However, as I listened to the first few minutes of Mr. Gordon's opening statement earlier today, it would be tough for me to say that was relevant, but that Mr. Clegg's testimony is not. That was my one impression. Do any other board members have any other thoughts or comments?
Yeah, this is Jordan White. I guess what I would say along the same lines is that, in the spirit of due process and there may be some redundancy, and certainly I don't know if we need to retread all the blow by blow of the CUP process unless it's relevant. But, I don't see an issue with, having him testify, just again, to the extent that we can avoid redundancy, that'd be great. But if there's something new or novel or important or relevant, I think we should, in the spirit of openness, allow him to testify.
Any other thoughts or comments or motions from the board?
This is Dave Clark. I'll move to receive it in evidence. I think it is useful background. It does certainly, I think, relate to some factual allegations included in the opening statements of Midway this morning. And so the process is an important context for our consideration, I think. So that's why I moved to receive it.
Does anyone want to second the motion?
I'll second. This is Jordan White.
Any further discussion? Okay, Mr. Clark, how do you vote?
I vote in favor of receiving. So
Thank you.
I vote yes.
Okay, thank you. Mr. Fitzgerald?
I vote yes.
Mr. White?
Yes.
Mr. Wright?
Yes.
Oh, and I forgot to do myself in alphabetical order. I've been trying to do it that way, but I vote yes also. So, do we have Mr. Clegg on the telephone?
Yes, sir, I'm here.
Okay, Mr. Clegg, do you swear to tell the truth?
Yes.
Okay, Mr. Reich or Ms. Gordon, go ahead.
Thank you. This is Brett Reich with Rocky Mountain Power. Mr. Clegg, have you reviewed the direct testimony prepared on your behalf for this proceeding,
Yes, I have.
as well as the rebuttal testimony?
Yes, I have.
And are those statements an accurate reflection of your testimony at this time?
Yeah,
And do you need to make any changes or additions to those?
I did not note any.
Okay. Let me just ask you one question also. On page 9 of your direct testimony, there's a statement that before the project can move forward, Rocky Mountain Power needs a clear decision and upfront payment for any excess costs. In your opinion, why is it necessary that this project proceed at this time and not be delayed?
As the board is likely well aware, it takes a whole lot of time. It takes years to develop a project. In fact, I've been working on this project for multiple years, and it was in some of the development for that. The issue that we have is that, it seems like everybody wants to be last in this case. We need an actionable decision now so that we can go out and acquire these rights of way, so that we can continue with the design, so we can order long lead materials, so we can, get the ball in motion to get this entire project complete for this needed reliability and capacity project. Continuing to delay this, any delay will just delay when this project will ultimately be done.
With that, then I'd like to proffer the direct and the rebuttal testimony of Benjamin Clegg.
Thank you. This is Thad LeVar. Noting that I assume Midway City and Volt both maintained their objections that we discussed a few minutes ago. Is there anything else anyone wants to add before we consider this motion? I'm not hearing any, so the motion is granted, consistent with the board decision a few moments ago. Thank you. Anything further, Mr. Wright?
Nothing further.
Okay, thank you. Mr. Gordon, do you have any questions for Mr. Clegg?
Yes, thank you. Good afternoon, Mr. Clegg. First question, did you listen to Jake Barker's testimony?
I did not. Pursuant to the board's request, I exited the room.
Thank you. First question, as a manager of this project, can the transmission line, if installed above ground, be finished by the end of 2020 at this point?
I would find it highly unlikely for either above ground or below ground by the end of this calendar year.
Okay. Have there been project delays that you've experienced due to the coronavirus?
I am unaware of any specific delays thus far due to the coronavirus.
In some of the bids, there was discussion about the cable coming from overseas, I believe Korea. Are you aware of any disruption in the ability or capacity to get the cable?
Typically, the utility would receive some level of force majeure letters on an active contract with a release against it. We have no active contract and we have no release against it. This actually kind of speaks to the need to move forward, because we have to have contracts in place to receive specific notification in a force majeure situation, like the one that you're walking down right now.
Okay. Has this process before the Utility Facility Review Board delayed the commencement of the project?
I would say that what's delayed the project is us trying to follow the conditions of this decision in November, or excuse me, in December. I understand the utilities proffered the information for the underground bids, and we don't have a decision one way or another. As I testified during the conditional use permit process, we needed to move forward as of the last quarter of last year in order to make sure that we were done by the end of 2020. We've lost time. I don't know if it was I wouldn't say it's because of this particular board review more than not having clear direction about what it is that we have been approved to build.
Okay. Is it fair, based on that testimony, to say that right now, if the goal was to finish by the end of 2020, we're probably at least maybe, 3 to 6 months beyond 2020 to finish this line now?
Yes, I think that would be fair to say.
Okay. Has RMP or Heber Light and Power obtained the needed easements to install the line?
Heber Light and Power had existing easements, prescriptive easements along this route, and has for decades now. And part of our agreement with Heber Light and Power is at the completion of this project, those would be apportioned. We have, as we testified during the conditional use permit process, we have acknowledged that there are some width deficiencies to upsize the voltage to 138 kV. Those specific additional easements have not been acquired, and we planned to acquire those once we had a specific actionable decision.
Okay. Where is Rocky Mountain Power in obtaining easements for the portions of the lines that were approved above ground in Wasatch County and Heber City?
They have started that process. I am not in a position right now to speak to the exact specific details of that.
Okay, but to your knowledge, they don't have those easements yet, correct?
I understand that not every easement has been acquired, correct.
Okay. As the project manager, how long do you think it will take to obtain the easements through Wasatch County and Heber City?
That's a good question. In my experience, the two things that are really, really hard to pin down on how long they'll take are easements and conditional use permits. And they can take anywhere from a few weeks to several months, or as we see here, years to get done. So it really depends on the level of concern about a specific project, other friction issues. We may have to even use condemnation or some form of eminent domain. Ideally, we don't have to walk down that road that far. But yeah, it can take months or years depending on the specifics of a project.
Have you been involved in the condemnation process in past projects?
Yeah.
And in your experience, how long does it take if you need to condemn and go all the way through? What has your experience been in the length it takes to get there?
What would you define as the starting point?
When you file a lawsuit.
So typically, as you probably are very well aware, there's an ombudsman in the state that is set aside to make sure that in the event of these types of proceedings, that parties are treated fairly. So if we're starting at that point, the assumption would have been that we would have already contacted these landowners, provided them information about their rights under that act, and we'd reached a point where we couldn't resolve it outside of a condemnation procedure. Typically, it's a matter of months before we could get a granting of occupancy. The case may continue for much time after that, even potentially, months or years. However, access to the property itself to be able to construct needed facilities is usually only months out rather than years.
So is it fair to say normal process would be anywhere from maybe 6 to 8 months to get to a point if you've gone through with the state ombudsman and then filed a lawsuit and finally gotten an order where you can possess the property? Is that a fair kind of guesstimate of how long that would take?
My experience has been it's taken less time than that. It's been more in the 2 to 3 month range. And, I think one of the critical points here is that we have to know what it is that we're going to build. We have to know specifically what and where so that we can go and acquire those easements.
If this board chooses to impose a commencement date on the Midway City, just the Midway City portion of the line into the spring of 2021, what impact would it have on the rest of the project?
It would not be possible to tie the 138 kV line between Midway substation and Jordanelle substation, as I outlined in my direct testimony, which would deprive the project of the needed reliability components.
So during the time that you're building this line, the line's not going to be energized until it's complete, correct?
Until the entire line is connected between Jordanelle substation and Midway substation.
Mm-hmm. So that means that the portion of a line could be constructed in theory in 2020 and the remaining portion in 2021, correct?
Yes, a portion of the line could be constructed at a later date, but you wouldn't derive the benefits of the portion that you've started to construct. It needs to all be done.
So, and I guess the question is, if that were the scenario, none of Rocky Mountain Power's clients would be without power if this were to occur, where we had to push it over into 2021, assuming that none of the other 138 kV lines go out, correct?
Could you restate the question? I don't know that I'm following you.
Sure. So if, how do I state this better? While you're building this line, whether it's energized by the end of 2020 or energized at some point in 2021, right now your clients are not relying on this line, correct?
Correct. It's not in service yet. Yeah.
Right. So if it takes a little bit longer to build the line, none of your clients are going to be without power, correct?
I don't know. I testified to this at the CUP hearings as well. I'm not the transmission planner, although, as in my role as project manager, I work with all of the various engineers and all of the various disciplines on the project, and I'm familiar with the purpose and need. If there is specific events on the system, it could deprive individuals, groups, even all of Heber Light and Power's load from power, depending on the severity of the event. It may or may not.
Right, but so assuming that none of the other 138 kV lines go out, there would be no negative consequences to the system if it took a little bit longer to build this, correct?
The negative, I guess, assuming in that extremely narrow, criteria that you outlined, that's true. However, delaying the project does deprive all of the other adjacent substations of the reliability in case there were an outage. It's a really weird way to ask it's boxing it in extremely tight.
Well, I'm just trying to establish that this line is, if it takes a little longer to build, your clients are not going to be without power, correct? That's all I'm asking.
You're asking a question regarding load, and the system isn't operated as a load-only concern. There are reliability components with that. especially on 138 kV lines that are, regional transmission in nature. You can't have that much load hanging out on the, we'll hope there's no outages.
But that's what you're doing currently, right?
Your question is, if everything is perfect, will it still be able to serve all the load? My understanding is yes. However, that's not the criteria that the area planners and transmission planners and system operators have to operate within. That is a false condition for a question.
Well, I disagree, but I think your answer is no, you won't have anybody without power if this gets pushed a little longer, correct?
Provided that there are no system interruptions on any of the 138 kV lines feeding the Park City region. That is my understanding.
So if you were to start this project tomorrow, and let's say it goes above ground, how long does it take to finish it?
As we had discussed earlier in this cross, the two things that are hardest to pin down are easement acquisition and conditional use permits from a schedule perspective. We would target having it done by springtime next year. 2021 would likely be the outcome based off of getting an answer right now.
Okay. So given that that's the best case scenario, is there a scenario where Midway City could seek to pass a bond in November and have the money for the excess costs in February and not interfere with Rocky Mountain Power's critical path on the project?
So in that scenario, what activities would we be able to do between now and Midway City proffering those funds?
So it's my understanding that you've already got conditional use permits granted through Wasatch County and Heber for approximately 6.3, I believe, miles of line, correct?
Okay, we already have it with conditional use permits? Yes, we already have that.
Yeah, so what I'm saying is there any reason why you couldn't install that line now and install the Midway portion in the spring of 2021?
Again, what activities in Midway do you expect that we would be able to do between now and November?
No, I'm asking the questions. So I just need you to answer my question.
Well, I need to understand the extent of what the question is. I'm not trying
Okay, let me explain it again. You have a granted conditional use permit to put portions of this transmission line above ground in Wasatch County and Heber City, correct?
Yes.
And the only thing that's stopping you from proceeding or commencing in those jurisdictions is you still need to get the easements, correct?
We are still working on easements, but we are doing design. We're ordering long lead materials now. We're ordering conductor. We're ordering steel poles.
And so, and how long do you think it's going to take you to get all of your ordering and materials here so that you could actually start installing the line?
Fall time frame this year. It'll be fall time frame this year.
So, okay, so we're now pushing it to the fall, and then once those get here, how long will it take you? Let's assume everything now is here. How long will it take you to build just the Wasatch County and Heber City portion of the line?
It'll be a couple of months. It will depend a little bit on what Heber Light and Power's system outage constraints are to some extent. But it won't take more than a couple of months to complete that work.
Okay. Is it a realistic expectation that you would be done with that portion of the line before spring of 2021?
Yeah, it would be, in this scenario that you've outlined, it would be designed, it would be, all of the long lead material would be acquired, and it would be complete by that time frame. And that's why I asked the question. You asked, what would happen if we don't tell you to move ahead and provide funds to move ahead until November. The problem is that the line will be done everywhere else, and then we'll be an entire year approximately from November before we'll be able to tie it through. We can't even start on these same activities we're working on everywhere else. It will produce a delay.
So let me ask that question. If Midway City passes a bond, it will be in November of this coming year. And so you would know by November, from a design standpoint, what you would need to do to move forward. How long will it take you to do the design work and to order the necessary infrastructure and get that here so you can install the line underground?
It'll be another year from that date.
Why would it be another year?
In order to order, I'll just take steel poles, for example. And this is something that I also explained at the conditional use permit hearing. Once you know exactly what it is that you're building, the transmission engineer will take exactly what it is from a spatial perspective and create what's a free body diagram of pole loads on a pole. They send those out to specific manufacturers, and there's a bid process. That takes a couple of months to get done. And then after that's done, bids are sent back. Those bids are reviewed, validated that they meet the standards, and then a qualifying bidder is chosen, and then it goes into fabrication. Fabrication, depending on what's going on, I've seen anywhere from, on the low end of 20 weeks once an order is placed to have steel poles there, to as long as I think 46 weeks is the longest I've seen. So, it from start to finish, you're somewhere in the 8, 9, 10 months from when you say go to the point when I can have a steel pole there. So going back specifically to why does it take that long? Well, if I don't have funds and don't know this is exactly what it is that we're doing, we can't start that design, so I can't go out and get the specific bids for those dead end poles. But the same thing happens with the other parts and pieces of the work.
And that was the next question I had. Is there any difference between, in the underground scenario, we're only doing 4 poles versus many more on the above ground? Does that cut your time when you're only ordering that many?
Is your question, does it take less time for underground because there's fewer steel poles? Is that?
My question is, if you go above ground, you've got to do, from my understanding, more engineering, you've got more steel poles, you've got to do soil analysis, all that kind of stuff. And my question is, will the time be reduced because you only have to do 4 poles?
I wouldn't think it would be materially reduced. If you go the underground option, you would spend, the conductor will have to be manufactured and sent to the site. You have to open up the road, you have to build it. You're going to be similar time frame. While the geotechnical studies that are going to have to be done, they differ slightly, but either scenario requires those studies. I don't know that it's accurate to say that there's less engineering required. There may be less steel poles specifically, but you still have all of your standard design tasks. You're just designing something else.
Okay. Is there any reason why construction cannot start on the north end and come Midway City's direction so that Midway City's portion of the line could be installed last?
Well, I'll answer that in 2 parts. One, we've already, that is currently the plan. We are moving forward acquiring easements. We're moving forward ordering steel poles, finalizing our engineering for that. And if we do not have a design that by the time, for Midway specifically, by the time we have a clear and actionable direction on what it is exactly we're doing here, we will go out to bid. However, one negative with that is that we're going to be
yoked, saddled with a lobe and delobe costs for a contractor. If they have to, show up and complete something, and then the design finishes for some other section, we've got to get them back there to the site to finish up.
And what do you assume, in your experience, the remobilization cost would be back in the spring of 2021 and finish it up?
It depends on the contractor that wins the job. Some of them are closer than others. It can range, I think, anywhere from the low tens of thousands to even $100,000. I would expect, something more towards the lower end of that, lower to mid range of that in a scenario like that.
Okay. How much does weather affect the critical path?
For construction specifically, for construction activities specifically?
Yes, I guess my question, let me be more specific. What weather conditions would stop construction on a transmission line?
We're able to in the event of a specific, incident, we're typically able to respond to restore power at any time of year. However, typically we would try to construct, not at the top of a mountain range, for example, in the middle of winter, but we can. It really depends on other externalities, like what's the driver behind the project, how critical is the need, are people without power, all of those things go into it. So there are means and methods and techniques to construct any time of year. This project is predominantly in a valley floor. I would expect we'd be able to construct really at any time. You're going to have to deal with some frozen ground issues and some of the things like that, which would not be necessarily preferred. The other thing that is considered along construction windows that is not necessarily dealing with frozen ground is system operation. And if it is a summer peaking or winter peaking area, or there's other drivers on the system, you may or may not want to be doing and taking lines out to do specific portions of work. So I don't know, I can give you just like this is the acid test for every scenario.
Yeah, no, but that's helpful just to kind of understand. Is it common? I'm guessing you normally try to plan your project so that you're not building through the winter. Is that correct?
Yeah, we would normally try, yes. Yeah, and so we would identify these sorts of constraints at the beginning of project planning, and then we would plan around those as efficiently as we could. If there's other externalities that would influence it, and we still have to have it done by a specific time, we might make adjustments. But yes, typically it's going to cost a little bit more to construct in the winter, and so we would avoid constructing in winter. It's also a peak load season. Even if it's not the control, it's usually a higher load time depending on the area, so you would typically avoid doing those types of activities during peak system.
Okay. In the scenario that I've asked you about before, where you begin construction and right now and start moving it forward, would the plan include having to continue through the winter to get it finished?
Yeah, I think we would have to be able to identify exactly when we could start. We'd have to identify what the constraints are that Heber Light Power System Operations is going to be dealing with, and then we would map that out. Depending on their loading, there very well likely could be times when we couldn't have a certain section of line out, but we might be able to plan around constructing other facilities at the same time. It just depends on when we can get everything here and ready to start.
Okay. So assuming, it sounds to me like, it sounds like probably December, January, February would probably be the worst months that you would be trying to install a transmission line, correct?
It can be, in the north, if we're talking specifically about this project, we might target to do specific tasks during those months as well. say in the North Fields area. We're not even talking about this permit at this point, but in the North Fields area, say you're crossing a wetland, you can sometimes access property when the ground's frozen and do less damage. So there may be some targeted activities that we would do, but we would typically try to avoid that.
Okay. Let me look through here. As far as the bidding goes, just a couple of quick questions. Isn't it true that it's fundamental to get an accurate bid that you need to have the correct length of line that you're laying?
Is saying for the bidders to verify the line length?
No, I'm saying, it seems fundamental that in order to get an accurate bid, the line lengths in the specifications have to be accurate, correct?
So, yeah, we would typically expect our contractors to verify specific lengths based off of the information provided in the documents, the bid documents. It would be critical to have accurate information. I'd say that the typical process that I've experienced at Rocky Mountain Power that I've been involved with is you create a specification, bid documents, and they have certain lengths in there, and then the bidders verify the lengths. And it is a fixed fee, a fixed cost bid that is that's given. It's not really an estimate. I would say it's probably, from how work is typically done with Rocky Mountain Power anyway, it's probably more important that an estimate have an accurate length than the bid. The bidders are provided the route, the bidders are provided where things start and stop, and they're expected to do their own takeoffs. In fact, typically, and I'm not familiar with this particular bid event in that level of detail, but typically there's even a statement in the bid documents that says something to that effect.
Okay. Were you involved in creating any of the specifications for the bids to go underground?
I was very high level involved with some of the discussions. I was not involved in the day-to-day components of that.
Okay.
I'm generally aware of Pacific Corp standards. I'm generally aware of what happened on this project as well.
Okay. Were you involved in the decision to include in the specifications dual trenches to go underground?
Yes, I had understood that dual trenches were included as part of Rocky Mountain Power's standard.
And do you know if there's any safety standard or reliability standard that's tied to?
Yeah, the IEEE puts out NESC, and it's refreshed every 5 years. The last version was published in 2017. And just, if I can give a little bit of background, the bid document was prepared based on Rocky Mountain Power's standards and standard specifications. And those standards are largely based off of the NESC as well as, best practices in the industry, et cetera. My understanding is, so RMP standard has separate conduit duct bank systems. And my understanding is, I am not the person who wrote the standard. The standards department did. This was published years ago, before this project was even, discussed at Midway. They just applied that standard to it. But Section 32 of the NESC 2017 320A1A, conduit systems should be subject to the least disturbance practical. Conduit systems extending parallel to other subsurface structures, and that's any sort of structure, should not be located directly over or under other subsurface structures. If this is not practical, the rule on separation as stated in Rule 320B should be followed. It continues later on in that section, same section. So this is 320B1 general. The radial separation between a conduit system and other underground structures should be as large as necessary to permit maintenance of either the conduit system or the underground structures while limiting the likelihood of damage to the other. These separations should be determined by the parties involved. Later on in NESC, this is section 352E. It says supply cables shall not be installed in the same duct bank with communication cables unless all of the cables are operated and maintained by the same utility. For that reason, it's my understanding that the standard is written the way that it is. We are separate utilities. We need to have separate duct banks. If we do not have a separation between those two duct bank systems and something happened where either system needed to be maintained, as it says in Part B, the radial separation between conduit system and other underground structures should be as large as necessary to permit maintenance of either the conduit system or underground structures while limiting the likelihood of damage to the other. Without that separation, I personally do not see how that would be possible.
Have you provided any of that information in your direct testimony?
No.
Let me just give a couple of thoughts here. So basically, just so I understand, you're saying that the NESC standards require separate trenches. Is that correct? And is that for a facility?
That would be my interpretation. Sorry, go ahead.
So let's just take one step back. So your interpretation of those standards is that it is required to have separate trenches, correct?
I don't know how you'd meet subpart or the Part B1. How would you maintain one conduit system without having some sort of radial separation? Yeah, but that's my interpretation. Again, I'll point to the fact that I didn't write RMP standard. As you pointed out, I am not an engineer, but the plain language of the code would seem to indicate to me that we need that separation, and that is why it is RMP standard, that's what the NESC requires.
And have you ever seen scenarios where RMP standards exceed the standards that are established in the NESC? Or
maybe there's different drivers behind it. There's some standards that are influenced by AFLIC to protect avian and other migratory bird. So it's part of the Bald and Golden Eagle Act and the Migratory Bird Act compliance. NESC is not necessarily driving that, but the standards are driven based off of varying codes. I guess NESC wouldn't require that, but RMP does follow AFLIC, which most utilities, or many utilities anyway, do as well. That's part of best practices.
Okay. I believe in the first part that you read to me, you stated that the goal of going underground is to have the least disturbance possible, correct?
No, it said, and maybe I misunderstood what you just said. What it reads specifically is that conduit systems should be subject to the least disturbance practical. So I interpret that language to say if you're going to put a conduit system in, it needs to be designed in such a way to limit disturbance so that's additional argument, I would say, to have a separation. If there even is an argument here, it's RMP standard, and it's what the NESC has said.
Okay. So based on, so your testimony is you've reviewed the NESC standards. You're not an engineer. You have interpreted them, but to your knowledge, well, first, this isn't necessarily your field of expertise, correct?
I've been in the industry for over a decade. I'm the project manager over projects that from the design end to the construction and turning it over to operations. And so I wouldn't say that it's not my field of expertise.
Okay. Does Rocky Mountain Power depend on you to do the NESC analysis?
As I mentioned earlier, they have a standards department. The standards department reads and interprets the various codes, including the NESC, when creating the standards. Those standards were applied in creating a bid specification.
Okay. And in your experiences there, you don't know whether these standards are directed at safety, correct?
The NESC, and I don't have that information directly available to me right now, but I believe in the preamble to the NESC that it states that that is the purpose of the NESC is safety. There are other standards that are looked at. I alluded to APLIC. It's I guess safety for birds, but it's not necessarily for human safety. There are various standards that the standards group looks at. It has, there's.
But I'm asking specifically regarding this idea that there has to be dual trenches. Based on what I'm hearing from you, there's nothing that you're aware of that says this is a safety standard, correct?
It is in the NESC, which is the safety standard that we have to follow. So I would say yes, it is a safety thing. That's why it's in the code.
Fair enough. I don't think I've got any other questions for this witness at this point.
Okay, this is Thad LeVar. Thank you, Mr. Gordon. I think what we'll do is we'll take a break until 2:40, and then we'll return. As I indicated this morning, we do have to finish by 4 o'clock today, so we'll break until about 2:40, and then we'll move to any cross-examination of Mr. Clegg by Volt. So we'll be in recess for a few minutes. We are back in Utility Facility Review Board docket 20-35-3. And at this point, I think we'll go to Mr. Morris or Ms. Brereton if you have any cross-examination questions for Mr. Clegg.
Thank you. Excuse me. Thank you. This is Mr. Morris. One request I'd like to make before I start my questions. Mr. Clegg was referencing some written material during his testimony that hasn't been provided yet, and I wanted to ask that Counsel for Rocky Mountain provide an email out both to the board and to council this NESC 1B language that he was reading from, as well as the Rocky Mountain Power standard that he referred to.
Mr. Wright, do you have any objection to that request by Mr. Morris?
Yeah, my one concern, and I can maybe look into this a little bit more, but the NESC code, like some codes, you have to actually purchase that. There's some copyright protections, and so I just want to make sure that we're not going outside. I don't have any, obviously, any concerns sharing it, but I want to make sure that we're in compliance with any kind of a license agreement that we have on that.
Mr. Morris, is it acceptable to you if we revisit this first thing in the morning and with the ability to recall Mr. Clegg if necessary?
It is. I'm just concerned about things being read into the record that none of us have in front of us. So.
Okay, but it's acceptable to you if we address this issue at the beginning of the hearing tomorrow again and see if we have a resolution?
Yes, please. That's fine.
Okay. Would you like to go ahead with any questions you have for Mr. Clegg?
Yes, thank you. Good afternoon, Mr. Clegg. My name is Mark Morris. I represent Volt in this proceeding. You were the lead project manager on this project from 2015 to 2019?
Yes.
Why did you cease being the project manager?
I had a contract with the utility. The contract ran for a specific period of time. They're transitioning away from that contract mechanism, and so I'm in a transition phase at this point.
Okay. So are you currently employed by or contracted with Rocky Mountain for anything?
The company I work for, I've been a consultant working on projects for the utility for the last 5 or 6 years. At one point, I was a full-time employee, and I left for a couple of years and then came back as a consultant. The company I work for has a contract with Rocky Mountain Power, and that contract is still active at this point.
Okay, thank you. Do you have your direct testimony, your written testimony in front of you?
Yes.
On page 2, line 25 and 6, could you go to that for us?
The copy I have has every page listed as 9.
You know, so did mine. This is the second page of testimony.
Okay.
And so at lines 24, 25, and 26, you say, due to various changes in technology standards and best practices, the physical difference between a 46 kV transmission facility and a 38 kV transmission facility built to the current standard is nominal. You see that?
Yep, I see it.
First, and I'm not an electrical engineer. You described the 46 kV as a transmission facility. Is that? I've heard these referred to as distribution lines rather than transmission. Is there any art to this?
In the state of Utah, distribution voltages have historically been 4 kV, and then they changed those to a 12.5 kV nominal voltage. There are I think maybe some interpretations to say that some of the higher voltages, 25 kV or something like that would be, but all of, I'm aware of a little bit of 4 kV in the state of Utah, and the rest of it is 12 kV as distribution. Once you get into the 46 kV, you're historically been dealing with regional transmission lines, and just as 4 kV was superseded by 12 kV, 46 kV is being superseded by 138 kV. And a lot of that is driven by the fact that the parts and pieces that you use with the current standards are nominally the same. They're pretty much, they're very similar.
And I wanted to ask you about the word nominal. Is that a word that you use in your parlance, or did Rocky Mountain's lawyers suggest that word to you?
That was my parlance.
Okay. Could I ask you to look at Volt Exhibit number 3? You have that in front of you.
I'm getting there. Bear with me. Yeah, I have it in front of me.
Okay. You're familiar with Highway 40, are you,
Yes.
Heber?
I am.
And there are 2 pictures in Exhibit 3. One is, it looks like it's along Highway 40. Do you see that?
Yes, I do. I'm familiar with that structure.
Okay. And is there a word that you insiders use to describe the pole that appears in the left-hand picture in that exhibit?
It's a dead-end angle pole.
A dead-end angle pole. All right.
That's what I would call it.
Okay. And then there's a picture on the right. You're familiar with the route through Midway that...
Yeah, that looks like it's on Springtown Road, turning onto 970.
Okay. At this point, I'd offer Exhibit 3.
This is Thad LeVar. If any party objects to that motion, please indicate your objection to me.
Yeah, what's the foundation? Who took these pictures?
It doesn't matter.
Reich?
I'm sorry.
I just want to identify, was that Mr. Reich who asked the question?
Yeah, sorry.
Okay, thank you. Go ahead, Mr. Morris.
Who took them is irrelevant, Mr. Chairman. The witness has confirmed that he's familiar with both scenes depicted in these photographs.
We have no objection.
Okay, thank you. Any other objection from anyone? Okay, the motion is granted. Thank you.
Thank you. Mr. Clegg, would you look at these 2 pictures and tell me if you believe the physical difference between these poles is nominal?
Yeah, so the language in my testimony is talking about the design differences between a 46 kV line to today's standards and a 138 kV line to today's standards. The photograph on the right that you have listed as the existing HLP local transmission line, 45 feet tall, if constructed today, would not meet NESC. And so it's not something that could be constructed today.
So you're not suggesting that the change that Rocky Mountain would create along this line, if it goes overhead, is a nominal change, would you?
Well, what does the pole on the left, I'm familiar with the pole, but what does the pole on the left have to do with the pole on the right?
Well, Mr. Clegg, are you testifying that this pole on the left doesn't figure anywhere into the line proposed to go into Midway?
Well, we provided a rendering that included, if I recall correctly, the angle structures that go through Midway City. They don't have the 2 lowest distribution davit arms on it, which would have reduced the pole height to some certain extent, and it also would have reduced the diameter.
Do you remember my question, Mr. Clegg?
Is if the difference between the one on the left is nominal to the one on the right?
My question is, forget these pictures. Are you testifying that the change between what exists now and what Rocky Mountain proposes to install overhead is nominal?
Yeah.
So you don't think going from 45 to 100 feet in pole height is any big deal? That's a nominal change.
We have to rebuild lines to the existing standards to operate at the voltages that have, you know, a 46 kV line rebuilt to today's standard to a 138 kV line, the difference is nominal, yeah.
I'm not sure that answered my question. Are you testifying that going from 45 to 100 feet is nominal, as you define nominal?
I don't know how to answer the question on just what a 45-foot specific structure versus a 100-foot specific structure looks like. A voltage increase could produce something that would be nominal. I suppose there's scenarios where it could not be. In the conditional use permit application, we specifically mapped out what the pole heights would be. And if I recall correctly, through Midway, the tallest pole was 88 feet, and many of them were closer to 75 feet.
Let me have you look now at Volt Exhibit 12.
Okay.
Have you seen that document before?
Yes, I have.
Could you tell the board what it is, please?
This document was prepared as part and submitted to Midway City during the Planning Commission hearings as part of the conditional use permit process in Midway City. There were three separate versions created, option A, option B, and option C. Option A and C was for a shorter span overhead and an underground, and what the impact would be as far as additional easement width required. What we're looking at is option B and the pole placement compared to the existing poles, as well as what the additional easement overhang would be by upsizing the voltage from 46 kV to 138.
I'd offer Exhibit Volt 12.
This is Thad LeVar. If anyone objects to the motion, please indicate your objection. I'm not hearing any objections, so the motion is granted.
Mr. Clegg, at the top of the page, it says for the existing 46 kV line, the existing easement is 27 feet from the center line.
I see that.
That means the width of the easement is 54 feet as it exists now?
No, what that means is if you do the math after blowout, that you would need 27 feet from the center line to safely operate and maintain that transmission line.
So you're not claiming that Heber Light and Power or Rocky Mountain has any existing easements through Midway that are 54 feet wide, are you, today?
I'm not. Can you restate the question?
You're not claiming that Heber Light and Power or Rocky Mountain Power, for that matter, have any existing easements along this proposed route through Midway where the width of the easement is 54 feet.
I kind of feel like you're asking me to draw a legal conclusion on this, and I'm probably not the best person to ask that specific question.
Well,
Rocky
let me
Mountain
ask it this.
Power- Go ahead.
So the answer you don't know?
No, the answer is that I believe, so you're asking me a legal position, you know, and I deferred to counsel on those. As we've looked at this project, Heber Light and Power has a prescriptive right. In addition, the common area within the subdivision to the south of the transmission line has provisions for public utilities.
Well,
And-
Mr. Clegg, I'm sorry to interrupt, but right after you told us you're not a lawyer, you're going on to tell us all about easements and common areas that exist. And if you're going to claim you know this stuff, that's fine, and I'll ask you questions about it. But if you don't know and you're going to say you're not a lawyer, I would ask you not to go on and volunteer information that is not responsive to my question. So are you qualified to tell the board about existing easements and the easements that are necessary to build the line that Rocky Mountain proposes to build?
I am familiar with the transmission route. I am familiar with the discussions that I've had with our counsel regarding our legal position on what the easements are or what easements are there. I am not an attorney. I'm certainly not an easement expert attorney.
Okay. And right now, you're
familiar with the route. We did the calculations to make sure that the legal position is...
Mr. Clegg, there's no question pending.
Okay.
You're sitting in a room with Rocky Mountain's counsel now, aren't you?
Yeah.
Okay. So on this chart, Volt Exhibit 12, someone said the existing 46 kV right-of-way is 27 feet from the center line. Do you see where I'm reading from?
Yes. Yes.
Okay. Do you know who's responsible for that language?
Yes.
Who?
We had our transmission engineer run calculations for the 46 kV line pursuant to current standards and what easement width would be required for that. And we did the same thing for a 138 kV line, and that's where those two figures came from.
Okay, so it's the transmission engineers, is that what you said?
Yeah, the transmission engineer did the calculation for the width, and then we provided that information to a surveyor and spotted the poles accordingly.
So, tell me if you know the answer to this question. Does Rocky Mountain claim that there are existing rights-of-way that are 54 feet long or wide running through Midway today?
Yes.
You know the answer to that question?
Yes.
Okay, and what is the answer?
The answer is yes. The prescriptive right extends 27 feet from the existing center line to the south today.
And that's information that you have been providing to other witnesses in this case. For example, the appraiser, that he should assume there are existing rights-of-way that are 54 feet wide running all the way through Midway, correct?
I would object to that question. That assumes facts, not an evidence. There's no evidence that Mr. Ben here supplied that information to the appraiser.
Go ahead,
Mr. Morris, you want to respond to the objection?
Well, yes. I think Mr. Clegg could have given me that answer rather than having his attorney suggest it. The question was, does he know if anyone has provided that information to appraisers? And he can say, I don't know, without the attorney telling us all he doesn't know.
That wasn't the question. The question was that Mr. Clegg provided that. So I have no objection to that question.
Okay. Mr. Chairman, let me withdraw my questions and I'll ask a new one.
Okay, I'll refrain from ruling on the objection in that case.
Thank you. Mr. Clegg, do you know whether or not the appraiser Rocky Mountain has hired to give opinions in this case was provided an assumption that the right-of-way for the existing lines running through Midway is 54 feet?
I don't know.
Okay. Have you read Mr. Lefevre's direct testimony?
I skimmed through the majority of the documents. I don't recall that specifically, if I've read his testimony.
Okay. Did you read the report that he attached to his direct testimony?
I can refer to it.
No, that's not my question. Have you read it?
I did read it. I did read it. I don't recall specifically all the details on it.
Okay. Looking back at Volt Exhibit 12, it appears that Rocky Mountain is suggesting the only additional widening of an easement that is going to be necessary to install this option B is just adding another 2 feet from the center line from existing rights-of-way. Do you read that the same way that I do, Mr. Clegg?
Yes.
Let me have you look at another picture. If you look at Volt number 6, let me know when you have that in front of you.
I have it in front of me.
Okay. I'm going to represent to you this is a portion of the existing line in Midway and ask if this is at all familiar to you. Have you seen this before?
I don't know for sure exactly where I'm looking, to be honest.
Well, let me ask a hypothetical. If the power line that you see in this picture is part of the existing Hebrew Light and Power line running through Midway, would you agree with me that there is not an existing right-of-way that runs 27 feet on either side of that power line?
I would not necessarily agree with that statement.
Why not?
Because the existence of a power line does not preclude any other facilities being within that easement area. You can have other things there that, as long as the other use doesn't preclude the safe operation of the transmission line, they could both be there in the same location.
Is it okay with Rocky Mountain for trees to get as close to these lines as the picture depicts?
Typically, they would try to do more consistent vegetation management than that. However, I'm not familiar with Hebrew Light and Power's vegetation management schedule and practices.
All right. Let's switch gears here and go back to the historical process that you testified to in your direct. You testified that Rocky Mountain and Hebrew Light and Power were working together to reduce impacts on Midway with this line. Do you agree with that?
Midway and the rest of the region, yes.
Okay. And would you agree that the impact on Midway would be less with an underground line than going overhead?
I don't, I can see how there are some people who would probably feel that way. There might be others who feel differently. I don't know that I can say definitively that one is less impactful than another.
Have you personally spoken to any landowners along the route that you were managing for between 2015 and 2019?
I've spoken with a handful of landowners. I don't know that I've had specific easement discussions with anybody in Midway.
Did any of those landowners tell you that they welcomed these overhead lines and taller poles and wider poles coming into the neighborhoods?
Occasionally, I've had some people who live adjacent to a line say that having a line higher doesn't, it affects them less than an existing line because they're not looking at the conductors. Specifically in Midway, I don't recall having anybody say that to me. And there's, as you well are aware, there's a lot of discussion about an underground line and a preference for that.
Okay. If the city of Midway and its citizens collectively were to tell you that the impact on Midway would be reduced, consistent with the goals you described Rocky Mountain and Heber Light and Power as having, you wouldn't argue with that, would you?
I think they're welcome to have their opinion, and I don't think that Rocky Mountain Power, per the statute, has any right to have a concern about whether it's overhead or underground. I don't think that that's been at issue at all in any of this. It's really been getting a clear, decisive decision and who's going to pay.
And we'll get to that last part of your direct testimony at the end here. Let's talk about, earlier on, I think you told Mr. Gordon that the project design was not yet complete. Is that right?
In Midway City specifically, or where are you referring?
Well, let's start there.
Yeah, so preliminary engineering activities have been completed. That's how we were able to produce the documents that were submitted with the conditional use permit. Until we have something that's clear and decisive as far as what exactly we're going to be doing and where exactly we're going to be doing that, we can't proceed any further on engineering tasks through the city. In other areas of the project, as I have in my testimony, there's portions of OPGW that are part of this project that have already been installed north of Jordanelle, as well as coming up Provo Canyon. And design is moving forward in other parts where of the transmission line where we have permits in hand. And then there's work along Highway 40 that's complete.
At least for the Midway portion, project design is not complete, correct?
Correct. We need something actionable from a decision perspective to move further along that road.
And you haven't ordered, or to your knowledge, Rocky Mountain hasn't ordered any materials yet for the Midway portion, has it?
I'm unaware of any materials ordered for the Midway portion.
What do the words radial separation mean to you, Mr. Clegg?
Can you provide a context?
Your testimony about a half hour ago.
Is this from the NEFC?
Those are the words I heard you use a few times. Radial separation.
I would say horizontal separation, because earlier in the, I would say that, it means separation laterally, with some distance apart.
Now, why are you inserting the word horizontal and lateral when the section you read from says radial?
Because other parts of the same code indicate that they can't be above or below.
Could you give us those citations so that when I ultimately get this, I can look at that myself?
Yeah, that's the first part that I read. It's 320A1A, and it says conduit systems should be subject to the least disturbance practical. Conduit systems extending parallel to other subsurface structures should not be located directly over or under other subsurface structures. It is not practical. The rule of separation as stated in 320B should be followed. And then 320B says radial separation between a conduit system and other underground structures should be as large as necessary to permit maintenance of either the conduit system or the underground structures while limiting the likelihood of damage to the other. These separations should be determined by the parties involved.
Okay. So those separations have not been determined by the parties involved yet, have they?
I don't know I can answer that. I wasn't involved with those discussions.
And in your mind, is there a difference between digging a trench that's 2 feet wide and digging 2 trenches that are 1 feet wide and spaced a bit apart?
Yeah, I think that there would be. I don't necessarily believe that that's what you would do in this case. I think you would open one trench and then you would provide a separation between duct banks that you formed in that one larger trench.
So right now, Rocky Mountain doesn't know how far apart the 2 trenches that it wants the contractors to dig would be.
Are you asking me that? I don't know the answer to that.
Yes, I am asking, and you don't know.
I don't answer that question.
Okay. And is it your testimony that you can't dig one trench and just put one conduit on one side and one conduit on the other and achieve a lateral separation that the parties could agree on?
I think that you'd have to determine a specific distance based off of the depth of those facilities and how they interface with other underground obstacles, say water lines or sewer lines, et cetera. You have to consider all of those things. Depending on the circumstances, you may or may not be able to open up one large trench and then form 2 duct bank systems on either side of the trench with some separation between the 2 duct banks.
By the same token, you don't know how hard or difficult it would be to dig 2 different trenches going through the same ground for the same reasons, right?
Yeah, you would have some of the. I think you'd have much of the same issues, and you might have some additional issues as well, but somewhat similar issues.
I mean, in your experience, it might even be harder and more expensive to go with 2 trenches rather than one that's just a little wider.
It really just depends on what underground structures there are. I mean, I suppose there are scenarios where it could. There are scenarios where it could be more difficult. It really just, are you talking about additional roadway that you're going to have to repair now? Are you talking about, maybe you can miss some underground structures by separating them? I think it really just depends on the specific circumstance.
Okay. I think that's fair. You said you were involved in the bidding or soliciting bids for the underground portion at a high level. Do I recall that right?
It's a relatively high level. I was generally aware of activities that were going on. I wasn't involved in the details of it, though.
Okay. Do you know if any of the bidders, any of the 18 purported people that were asked to bid, were invited to make a recommendation as to whether they would go with 1 or 2 trenches?
I can't speak to that. I don't know.
Okay. So on the real page 9 of your direct testimony, I know they're all marked 9, but this is the real one, the 9th page.
Okay,
You there?
does it say summary of testimony?
Yes.
Okay, yeah.
Right at the bottom, lines 30 and 31, you say, before the project can move forward, Rocky Mountain Power needs a clear decision and upfront payment for any excess costs. You see that?
I do.
How do you calculate excess costs?
The standard cost, the difference between what, I'm not using the legal language for that. It's the difference between what a jurisdictional entity requests us to do or conditions us to do and whatever our standard cost is.
And the standard cost against which you want Midway to weigh the excess costs included an estimate of around $27,000 to obtain easements and rights of way. Do you recall that?
Yeah, I believe through the permitting process, one was provided and then it was updated. We provided one initially based off of RMP's internal estimates, based off of 3 different groupings of property uses, and it produced ranges as you described. And then later we had an appraiser do a similar task. It wasn't, and we applied the same square footage impact for new easements, and it varied a little bit, but it was within $5,000. So it was, like you say, that $20,000 to $30,000 range.
And could you tell the board whether standard cost, as you described it, should or should not include the money Rocky Mountain is going to have to spend to pay landowners for additional wider easements and severance damages?
This is Brett Reich. I object to the question. It calls for a legal conclusion and an interpretation of the statute. The definition of excess cost is defined in the statute, and I think it's calling for a legal conclusion.
This is Thad LeVar. Mr. Morris, do you want to respond to the objection?
Your Honor, this witness used the word excess costs in his testimony, and he's told us he understands what standard costs are. I'm just asking him if that's consistent with his understanding to include easement, severance damages, rights of way with standard cost.
And the testimony is that the excess costs should be paid. It's not that what those excess costs do and don't include.
Yeah, Mr. Morris, if you could give me a little more guidance on did he open the door on defining excess costs or referring to excess costs?
Well, the summary of his testimony was this is what Rocky Mountain Power needs. They need a clear decision, and they want upfront payment for excess costs. And I'm asking him if he knows how Midway is supposed to calculate excess costs.
I'm going to overrule the objection on the basis that I think Mr. Clegg has probably discussed the issue enough to open the door to it, with the recognition that this is ultimately a decision for the board to make. So one witness's opinion of it has limited value to the board, but I think I'm not going to grant the objection at this time. I'll allow Mr. Clegg to answer the question.
I'll ask it again, just for clarity. Standard costs include right-of-way and easement costs, don't they?
That's my understanding.
And today, Rocky Mountain doesn't know what its standard cost is, does it?
We have estimates of what the standard cost would be to construct an overhead line and acquire those easements.
Mr. Clegg, when were you with Rocky Mountain Power in 2014?
I was consulting with them at some point in 2014.
Did you have any involvement in the project out in Tooele County involving SITLA?
I object to the extent this is irrelevant to the proceeding before us.
Mr. Morris, this is Thad LeVar. Do you want to respond to the objection?
If he says no to that question, I'll agree we can move on. But if he says yes, I'm happy to lay more foundation.
What relevance does the Tooele project have to do with the Midway City project?
The Tooele project is an example of where Rocky Mountain Power has come in with an extremely unrealistic, lowball estimate as to what the standard cost is going to be in building a transmission line that turned out to be just wildly inadequate. And the relevance is Rocky Mountain is engaged in the same process here of suggesting Midway is going to have to write a check for multi-millions of dollars because its standard cost is at X, and the evidence that we're putting on here shows it's X times 3,000, or 35 rather, 3,500% difference. But that's the relevance, Mr. Chairman.
And then I'm also going to object on foundation. I mean, there's no testimony or evidence that the same process was used to estimate the right-of-way in the Tooele project as was used in this project.
And I'm not offering it for the same process being used. It's just a fact in both cases that an easement number has come in that in both cases. And one, the Tooele example demonstrates Rocky Mountain's whether it's a process, whether it's a tactic, whether it's a strategy, or just a bad habit. They suggest that easement costs at the beginning are really, really low, and it's not the case. And they're using it here to suggest that Midway has a greater economic burden than it should bear.
Okay, Mr. Morris, this is Thad LeVar. I'm going to overrule the objection on relevance grounds, and with respect to foundation, I'm going to give you a few questions to see if you can establish the necessary foundation with this witness.
Thank you. Mr. Clegg, did you have any involvement in the SITLA line, or the transmission line that went through Tooele County on SITLA property back in 2012, 13, 14 timeframe?
I did not.
Okay. Let's move on. You testified in answering some of Mr. Gordon's questions about the length of time that it takes in order to go through the process of using the ombudsman and hopefully negotiating and hopefully avoiding having to file a condemnation action. And you thought that the process, in your experience, on a good day, goes 2 to 3 months. Do you remember that?
You're saying specifically on a condemnation proceeding, or specifically on what component of that? Design?
No. Let's limit it to obtaining easements from landowners.
It's all project specific. We have obtained them in as little as weeks, and it's also taken much longer than that.
Anywhere along the way here, have you gained an understanding that if this line goes underground, you won't need to negotiate with any landowners, that they will provide easements allowing for underground lines without charging money?
there's been statements made at public hearings that some people have a desire to donate whatever easements that would be needed for an underground line. I'm not aware of anything, I guess, of substance saying, you know, this is exactly how many, or this is all, or even that we have any of them to say, you know, here it is. I'm not aware of that, but I understand that there's some sentiment that there are some people who would, quote unquote, donate an easement for an underground line.
So the answer is yes, you have heard something to that effect?
I heard all in your question, and I didn't hear that all costs ever would be avoided by that, but I heard some people say that they had some desire to do that.
Fair enough. It would speed the process up for Rocky Mountain tremendously if it did not have to haggle and fight and eventually go to condemnation to obtain easements and rights of way, wouldn't it?
Saying if someone just handed us a bunch of easements and we could move forward comparing to have to go get them?
Precisely.
Yeah, that could save time.
I'm just checking off some things on my notes here. Bear with me for a minute. This is sort of out of order, but here I recall you testifying in response to Mr. Gordon's questions that one of the goals here is to avoid service interruptions if one of the three lines coming into Heber Valley goes down. Do you recall that?
Yes, generally.
Would you agree with me that in the last 5 years, even though there have been occasions when one of the lines has gone down, there have been no service interruptions to customers that you're aware of?
I'm not in a position to say whether that statement is or is not true. I'd have to go and ask people to produce information on that. I can't speak to that.
Fair enough. So when you were testifying earlier that you were trying to avoid service interruptions if one of the lines goes down, you don't know if service interruptions would really occur if one of the lines were to go down.
No, my statements during the public hearings, as well as here, have been informed on various discussions with area engineers and planners. The specific question that you asked was, are you aware of anything in the last 5 years if anybody specifically was dropped off? I don't know that. That's way too specific. The question that I answered earlier was, you know, what's the purpose of this project? What's one of the main benefits? And one of the main benefits is there's exposure to the system at certain times that if we have an outage under certain conditions, there would be major consequences to that. And I go ahead.
Well, even if you build this big line that is the subject of this, I mean, there are still circumstances that could occur that would interrupt service to end users, right?
I suppose that there are issues in the Park City Load area that, you know, that could happen, that could have that could result in outages. However, it's my understanding as well that from a 138 kV transmission perspective, we'll get back to being able to survive losing one of those lines and still being able to carry the load from an area transmission perspective. But again, you know, there's maybe other circumstances, or maybe you lose two lines and then something happens. You know, I think you've got other people that you can ask those questions to besides me from a system perspective.
Okay. Now, Mr. Chairman, this is I want to turn now to Mr. Clegg's rebuttal testimony. Although Mr. Weber, whom he rebuts, hasn't yet testified, I'm happy to do whatever the board prefers to do. I could tackle his rebuttal to Mr. Weber now, or if he's available, it might make more sense to tackle it after Mr. Weber has testified, but I'm happy to proceed either way.
This is Thad LeVar. I think it's more efficient to proceed while we have this witness on the stand. If there's a need to recall witnesses as we go forward, we can discuss those, and I think that's an issue we can go forward with, but I think it's probably more efficient to go ahead with the questioning at this point.
Okay, I'm happy to do that. So, Mr. Clegg, do you understand who Mr. Jerry Weber is?
Yes.
Who do you understand him to be?
I understand he produced certain appraisals for various personnel that I guess Volt represents, and compiled some of that information and then presented his testimony. He's an appraiser in Heber Valley.
And you're not an appraiser, are you, Mr. Clegg?
I am not.
Could you explain to the board what qualifies you to rebut the testimony of an expert appraiser?
I rebutted specifics within Mr. Weber's testimony that he offered, and there appeared to be some specific errors, as well as inclusion of people who are not along the route, where I'm familiar with the route, and I'm familiar with what areas require overhang easements. I was in a position to clarify those errors.
Now, you've made a point of telling us that you're not a lawyer, but are you now saying you are qualified to opine to this board what areas need easements and which do not?
Objection, that was not his testimony. That misstates his testimony.
Then I'm sorry I got it wrong.
His testimony was that he was aware of the location of the route and whether or not it touched or impacted the properties.
I thought he used
Thad LeVar.
I'm sorry.
Yeah, I'm going to sustain that objection, but if you want to rephrase the question, you may do so.
Okay. So I asked you what qualified you to rebut the testimony of an expert appraiser, and for example, on page 1 of your rebuttal testimony, lines 13 to 16, you felt compelled to bring up the fact that the same property was mentioned twice or described twice. You see that? Parcels 10 and 82?
Yeah.
Did you read all of Mr. Weber's testimony?
I thought I did.
Did you see on page 5 of his testimony that he noted the same thing that you did?
I did not.
Well, do you have his direct testimony in front of you?
I can get to it. His calculation did not included both.
Mr. Clegg, we're not talking about calculations yet. I'm just asking you to go to page 5.
I am at page 5.
Go to lines 98, 99.
I see that.
And you see where Mr. Weber made the same observation that you did, that 2 of the parcels were the same one?
I see that.
Okay. So you missed that when you went through his direct testimony the first time?
It appears I did.
On page 1 of your rebuttal testimony, so we're back on your rebuttal now, line 20, well, let's see. I think we've already covered that. Hold on. Have you read the direct testimony of Ron Lowry?
I don't recall reading that one.
Mr. Morris, I'm not sure that we have seen a filing of Mr. Lowry. Has that been filed in this proceeding?
I thought Mr. Lowry's testimony was filed along with Bank Johnson's. I sure
You're
hope
correct.
it was.
Yeah, you're correct. We did find it. Thank you.
Okay. So, Mr. Flake.
I don't recall that, no.
All right. I might be done. Let me check one thing here. Getting back to the last thing that you said in your direct testimony, that you want a clear decision and you want payment of upfront money. You understand that the upfront money would not be due to be paid until after your project designs and material orders were complete. You understand that?
I'm going to object to the extent that calls for illegal conclusions. I think the timing of when payment is made is contained in the statute, and I think it actually contradicts what you just said. But I think that calls for a legal conclusion.
Mr. Morris, can you respond to the objection?
Yeah, I'm happy to withdraw the question and ask another one.
Okay, why don't you go ahead that way?
Do you have an understanding today is when this upfront payment that you said Rocky Mountain so desperately wants would be due?
Objection. His testimony did not say that Rocky Mountain Power so desperately wants the excess cost payment.
Mr. Morris, could you rephrase a little bit more?
Yes. Do you know, Mr. Clegg, when the upfront payment that you say in your testimony is what Rocky Mountain wants, in addition to a clear decision, when that payment would have to be made?
Same objection calls for a legal conclusion and interpretation of the statute.
This is LeVar. I think I'm going to have to sustain that objection. That is a legal issue that's outlined in statute.
All right. The last question then is, it's a fact that as of today, for this portion of the line, the project design is not complete and the materials have not been ordered, correct?
For the Midway portion of the project, that's true. As I outlined earlier in this cross, other portions are complete or have started.
I think that's all the questions I have. Thank you, Mr. Clegg.
This is Brad LeVar. Thank you, Mr. Morris. Mr. Reich, let me ask you this question. We go to you for redirect next, but know that we do have to finish by 4 o'clock at the latest. We have one board member with a hard commitment where we have to close by 4. So do you want to do some redirect now, or would you rather us simply adjourn and begin with this first thing in the morning?
I think I'd get it done in the time we have left.
Okay, why don't we go ahead with your redirect then?
Okay. First, let me get back to your rebuttal testimony that you were just asked about, Mr. Clegg. Was your rebuttal testimony on page 1 with respect to the calculations that were made by Mr. Weber?
Yeah, specifically, I was referring to Mr. Weber having not removed or had included both 10 and 82 in the calculations that was attached as his exhibit.
Okay. And then also, you were asked earlier about the project schedule by Midway City, and I think they asked you what the impact would be, or why not delay this until November of 2020 when they could get a bond, vote on a bond, and then have that bond funded in February of 2021. What are your concerns, if any, of proceeding with that type of schedule?
It would put us in the same situation that we're in right now for the 2020-2021 load season. If we couldn't start on the design and material acquisition until that point, we would not be able to complete the project by winter load 2021, and it would very likely roll into the next spring.
And do you understand when the peak period is in this area in the Park City?
Yeah, my understanding is that, and I actually just alluded to that. My understanding is the peak load is in the winter. They have a summer peak as well, but regionally it peaks in the winter, and that's when the most exposure to the system occurs, which is exactly why waiting until springtime next year to be able to start on these other activities would put the system at risk for yet another winter.
Okay. Let me shift gears now to, there's a couple of statements in Midway City's trial memorandum that I wanted to ask you about. With respect to the bids, Midway City takes the position that the bids are so outrageously high and so far apart when bidding the same work that it destroys all credibility. Tell me a little bit about your background with respect to these type of construction projects. How many years have you been doing this?
Been doing projects for 16 years. I've been doing utility projects for the last 11 years, specifically for electric utilities. In that scope, I take a project and I'm involved with a project from the concept, from when there's a, purpose and need is determined and it goes out and it receives some level of funding, and involved with siting discussions as well as any permitting, both state and local, as well as any federal permits, oversee the design, and then go out to bid, and then oversee construction. Once it's done, it gets handed over to operations, and then they operate that. So it's really the entire development and construction of these projects.
In your former experience, have you had an opportunity to review bids on these types of construction projects?
Scores of times, yeah.
And is it standard for you to receive bids that are not the same, or they have some disparity?
Mr. Chairman, I need to object for two grounds here. One, he's leading his own witness, and number two, this is beyond anything that's been brought up before, disparities in bids.
Mr. Reich, this is Mr. LeVar. Can you identify if this issue was raised in cross-examination of this of Mr. Flegg?
No, it was not raised in cross-examination, but it has been raised by Midway City in their trial brief, so I'm just responding to that.
Okay, I think I'm going to sustain the objection for this witness. I think either with a different witness of Rocky Mountain Power or in a cross-examination of a Midway witness would be a more appropriate place for this question, where it hasn't been raised in the cross-examination of this witness yet.
Okay. In similar part of the Midway City brief, they talk about Midway City talks about a 2018 estimate to bury the entire line of 70 miles for $32.16 million. During the conditional use permit application in front of Midway City, are you aware of a study that was conducted with respect to the cost of burying the line?
Yeah, a study was originally conducted at the request of Wasatch County as part of their permitting process. And the project team, for various reasons, one of which was there was some concern about potentially the county or others questioning the estimate itself. We went to a third party. Heber Light and Power actually did the heavy lifting for that. Lower Valley up in Wyoming had just done a project, and through discussion with them, Jason Norland reached out to a company out of Colorado, I believe, named NEI, and they produced an underground estimate. It included the entire length of the line through county, cities, all of it, as well as various subsets of that. So various start and finish points if certain portions were elected to go underground. It was the nature, and I believe it's mapped out in the executive summary. The nature is really just to estimate costs. And if I actually read from it, the report focuses on costs but provides a short description of other considerations. Estimated costs have been provided by various entities and have been compiled to determine the cost per segment based on the segment map provided by Heber Light and Power. The purpose of the study is to provide an estimated cost within 30% of the actual value. It's meant to be a cost feasibility analysis. It is not intended to be a ready for construction design estimate. That's from the executive summary.
And is it during the bid application process and in the conditional use permit, is it your understanding, did Midway City accept this study that was conducted as the estimate of what it would cost to underground the line?
Mr. Chairman, excuse me, I wish Mr. Wright wouldn't lead his own witness. I object.
Mr. Wright, do you want to respond to the objection based on leading question?
Sure. I'm just asking him for his understanding of how Midway City, if they accepted this study in the conditional use permit.
Yeah, I'm going to rule that's not unnecessarily inappropriately leading, and I'll allow him to answer the question.
Yeah, my understanding that they rejected the estimated cost. That's how we ended up going out to bid to get actual bids from others, because they did not accept the estimated cost provided by us at that time.
Okay, I have no further questions.
Ms. LeVar, thank you, Mr. Wright. I'll go to Mr. Gordon or Mr. Jukes for any recross, but reminding you again, we have about 10 minutes left before we have the hard stop. So if you don't think you can complete any recross based on the redirect in that period of time, we probably should adjourn until tomorrow. So let me know.
No, we'll be done with that. Yeah, just a couple of follow-up questions here. Mr. Clegg, in the executive summary, just right underneath that in the NEI, cost estimate feasibility study, it establishes that the estimate for the Midway line was $6.38 million, correct?
Let me look at that. I want to make sure that I consider that entire length.
That would be line number 8, correct? 1.3 miles.
Yeah, I'm looking at that. Yeah, I mean, I believe it actually exits Midway and heads to the north in county for a portion of that, but it does cross Midway in Section 8 as well.
Okay, and then down below from Highway 40 to Midway, the estimate was $32.16 million, correct?
That's what NEI's estimate came to, yes.
Mm-hmm. And the highest bid that came in from the bidders was $28 million just for Section 8, correct?
I'd have to go back and refer to that. I know one's an estimate and one's a bid. I'm not prepared to answer that question specifically.
Okay. Just two more questions. So the NECS standards that you quoted today were not in either your direct or rebuttal testimony, correct?
Correct.
So just kind of regarding your omniscience here of kind of understanding what we would ask, what made you bring the code with you today?
This
This is Brad LeVar. Sorry, there hasn't been an objection, but I think the question was a little pejorative. If you wouldn't mind restating in a less pejorative way.
Oh, I apologize. I wasn't trying to be pejorative, and so if that was taken that way, I apologize. I was just surprised by the detail on something that was outside the scope of what you had originally testified to. So what made you bring the code with you today?
I'd understood there were some questions regarding a common trench or actually more specifically, a common duct bank system. And so prior to starting this morning, I had some discussions with the transmission engineer at Rocky Mountain Power and found the specific location where that information is called out. It was really just because I'd understood there was some concern regarding a shared duct bank system, and I wanted to be prepared to answer that question if it came up.
Fair enough. No further questions.
Okay, this is Brad LeVar. Thank you. Mr. Morris, do you have any redirect that you feel like you could do now, or would you rather hold it for first thing in the morning?
I don't have any questions. I'm just hopeful that this language and code section can be delivered to us before the morning, if that's possible.
Okay, thank you. And you do have our commitment to address that issue at the beginning of the hearing tomorrow. Let me go to then board members. Do you have any questions that we could address in the next few minutes? Or do any of you have questions that you'd like to hold and address with this witness in the morning? If any board members have questions for the witness, please jump in and let me know what kind of questions you have.
So this is Dave Clark. I'm going to tell you that I have no questions.
Okay, thank you, Mr. Clark. If any other board members have questions for Mr. Clegg, please indicate that. And I'm not hearing any questions. I do think we probably should have Mr. Clegg available in the morning as we deal with the codes issue and whether that can be provided to everyone. So we may need to have him available to answer any brief questions about that. But other than that, Mr. Clegg, thank you for your testimony today.
Thank you. And
we will be in recess until 9 a.m. tomorrow. Our first order of business will be dealing with these codes. And then Rocky Mountain Power has indicated their next witness is Darren Myers, and we have an objection to that witness, so we'll need to deal with that right off the bat as well tomorrow morning. So we will reconvene at 9 a.m. tomorrow. Thank you.
Mr. Chairman, is the dial-in information the same for tomorrow as it was today?
Yes, it will be the same all week. We just hoping not to distribute it too widely. It worked the audio quality was pretty good today without a lot of extra people on the line, and I was following the streaming, and the streaming seemed to be working well all day as well, so residents who are interested have been able to listen without having to burden the dial-in number. So that's a long answer to a short question. The short answer is yes.
Thank you.